So with the permission of Stefano sir and Principal Dr. Kranti Deshmukh ma'am, we'll begin with the inaugural session of our international conference. Welcome, Suswagatam, Beneventua, Benventino. On behalf of Marathwada Mitra Mandal and Marathwada Mitra Mandal Shankarrao Chavan Law College, Pune, India, the Competition Commission of India, that is under the Government of India, the Department of Legal and Social Studies, University of Chieti-Pescara, Italy, I, Savru Bubai, in charge of international collaborations, welcome you all to the inaugural function of the International Conference of Kaleidoscopic Vision of the Competition Law, A Way Forward, organized by Marathwada Mitra Mandal Shankarrao Law College, Pune, India, in collaboration with Department of Legal and Social Studies, University of Chieti-Pescara, Italy, under the aegis of the Competition Commission of India, Government of India, celebrating Azadi Ka Amrit Mahotsav. Marathwada Mitra Mandal is reaching to the corners of the world only because of the support and guidance and untiring efforts of Principal B.G. Jadhav sir, who is an executive president of Marathwada Mitra Mandal, with whose vision and leadership we have already started trading path of excellence at all 4 campuses and with almost more than 15,000 students, and with the proud that all these sister institutes received accreditation of A grade and Institute of Management with A+ grade by NAC. A true welcome is never complete without the warm words and the warmer gestures. So I request our respected principal, Dr. Kranti Deshmukh ma'am, to deliver welcome address and introduce our college and conference to the guest. Over to you, ma'am.
Thank you, Saurabh sir, and very good afternoon in India and good morning in Italy. It is really my pleasure to welcome all the guests and dignitaries for this 2 days conference, international conference on Competition Commission Law in India. First of all, I heartily welcome Chief Guest of today's program, Mr. Anuj Verma, who is Deputy Director, Combination Division, the Competition Commission of India. Sir, on behalf of Italy and India, both the organizers, I extend my warm welcome to you. Thank you, sir. With this, I also welcome Professor Stefano and Professor Ilaria from Italy. We are very grateful to you for this beautiful collaboration. This is virtual collaboration, but I extend my invitation for offline collaboration, and we request you to visit our institute and visit Pune, visit India. So this is beautiful collaboration, and we are very grateful to you for extending this hand. And I'm also grateful to the Competition Commission of India for jointly conducting this international conference with us. Because if we see what is the specialty of this international conference, that all the giant people, Competition Commission of India, the department from Italy, and from Pune, Savitribai Phule Pune University, Shankarrao Law College, we have united to discuss the Competition Commission Act and the challenges before it. So I think the outcome of this international conference will definitely add into the existing knowledge, and we will come out with very fruitful ideas, and we will be able to fill the gaps which are there in the present system. That is what is the aim and object of this conference. Now, shortly, I'll take this opportunity to introduce our Law Institute to all dignitaries and participants. Shankarrao Law College is established in the year 2003, and in very short span of time, the Law Institute became a renowned place for learning law, not only in India, but across globally. Around 1,500 students presently, they are taking education in our institute, and we are offering variety of courses from UG to PhD degree. we can say, because recently we have started our PhD research center of the college, which is affiliated to Savitribai Phule Pune University. So variety of programs, variety of departments, and variety of opportunities we always would like to provide our student. In short, if I want to mention about my college, I will just say, or I feel privileged to inform that the law college is accredited with A grade in its very first cycle by NAC accreditation Bangalore. So I am sure that we all participants and other faculty members, they are eager to listen the chief guest address and the address from the Italy. So without taking much time, once again, I extend my warm welcome to all to this inaugural function, and I request Saurabh sir to proceed with the program. Thank you so much for giving me an opportunity.
Thank you so much, ma'am. Thank you for your kind words and support always that you have provided since the formation of our college. And we are very fortunate that we have a number of collaborations with an international institutions and the national institutions as well. We are also thankful to Professor Fabrizio Fornario sir, who is the head of Department of Legal and Social Studies at the University of Chieti-Pescara, Italy. Now I request Professor Stefano sir, Professor of Public Law, Department of Legal and Social Studies, the University of Chieti-Pescara, Italy, to deliver a welcome address on behalf of the University of Chieti-Pescara, Italy. Over to you, sir.
Thank you very much. Thank you very much for the invitation. I'm so happy to be here. And I want to thank you all, patrons, co-conveners, students, colleagues, and particularly Mr. Saurabh Ubale. I don't know if the pronunciation is okay. He first contacted me for having, to thank him for having involved my department in the organization of this incredible and fascinating conference. Today, I also have the honor of representing the Department of Social and Legal Studies of the University of Chieti-Pescara on behalf of Professor Fabrizio Fornario. He could not be here as he is traveling at the moment. I want to also welcome today distinguished speakers, Mr. Anju Verma and Advocate Mohan Sharma. If I pronounce well the names. Let me start by saying that international academic cooperation and research are key to our university's mission. This is why my colleagues and I are keen to further our collaboration in the future. And well, a deeper relationship between our institutions may even depend to some extent on what we'll discuss over this two-day conference on kaleidoscopic vision of competition law. I'll hint at why it is so from my point of view. One of the main goals of what is the European Union today has always been to establish an internal market based on an open market economy with free competition. This is Article 3 of the EU Treaty, what this article provides. And this internal market includes a system ensuring that competition is not distorted. And it is generally claimed that the EU, and of course Italy is part of the EU, as one of the most robust competition policy systems worldwide. And the European Commission and the antitrust authorities of all the member states enforce the EU competition rules in close cooperation under the European Competition Network, so-called. And the policy, competition policy, also applies to non-EU companies operating on the single market. And of course, new challenges lie ahead, as always, such as reassessing the role of competition policy in shaping the European industry and dealing with the digital economy. Think, for example, of data, online platform, or mergers between incumbents, fast-growing companies with significant competitive potential. In this regard, effective enforcement of EU competition policy requires cooperation with competition authorities outside the EU, especially when it comes to globalized mergers, cartels, markets, and companies. To this aim, the EU Commission collaborates with competition authorities worldwide to promote the convergence of policy tools and practices and enable cooperation on enforcement activities with other jurisdictions. Moreover, the European Union, normally negotiates competition law provision in trade agreements, and free trade agreements should contain a competition chapter that provides rules and disciplines on antitrust, mergers, and subsidies. Here, what I alluded to regarding the broader context of deeper relationship comes. Following the EU-India summit in May 2021, talks on both a new India trade and an investment agreement have resumed, so very recently, and many commentators believe it is crucial to maintain momentum following this sort of breakthrough, taking advantage of the transformed geopolitical landscape since the last round of EU-India talks were abandoned in 2013. I believe that a full-fledged economic partnership agreement similar to those between the EU and other advanced economies such as Canada, Japan, etc., is in the EU and India's mutual interests. In that case, it is clear that a complete understanding of how competition law works is capital to draft the competition chapter of the agreement, I mean. Let us remind ourselves that the comprehensive trade and investment deal may address, for example, the roadblocks that occurred during previous negotiations between the European Union and India. Mainly, these were mainly, above all, digital trade and student and workers' visas. Then, student and staff exchange might be something to work on for the future regarding our beginning relationship with, that I want to take further, as I said before. But I want to conclude my welcome speech on a different note. Didier, one of the protagonists of the bestseller Shankarrao, quite disputed novel maybe, but very popular worldwide, by Gregory David Roberts, says that the Indians are the Italians of Asia and that the Italians are the Indians of Europe. And I quote, "Every man in both countries is a singer when he's happy, and every woman is a dancer when she walks the shop at the corner. For them, food is music inside the body, and music is food inside the heart. The language of India and the language of Italy, they make every man a poet and make something beautiful from every banality." It may sound cliche, nonetheless, as always, cliche contains a grain of truth. And so I'd like to think that this similarity is the best guarantee to make our effort a success. Thank you.
Thank you so much, sir, for your words. So words of wisdom that definitely guide us out of the conference and to have more collaboration with the university belonging to Italy specifically. So thanks a lot, sir, for accepting our invitation to collaborate and to have a tri-party collaboration with the college as well as with the Government of India, the Competition Commission of India. Now moving ahead with the next segment, and that is about the international conference. In 2019, we have started with having an international collaborations with a number of universities all over the world. In 2019, January, we had offline conference with the Faculty of Law, the Colombo University from Sri Lanka, and more than 10 delegates of Sri Lanka, they visited our campus, and we had 2 days international conference specifically focusing upon the technological realm of the human rights. In the next part, we have come up with the book on it, the edited book with the collaboration of the same university. In 2020, we had a collaboration with the University of Peru, where we had an international conference on the constitutionalism, international law, and public policy 2021 ahead. So we had also come up with the research and the edited book on the same topic. We had an international webinar where various resource person all over the world, from China, Nepal, Bangladesh, number of countries. Their resource person, they have virtually joined our international webinar to guide our students on law and the careers in the legal fraternity. Last year, in the month of November, we had a collaboration with International Mediation Training, that is LLC, from the United States of America. And currently we are having a research, a collaborative research on the mediation in India it was funded by the United States of America. So here we are excelling in the field of the international collaboration, so that the students from the campus, on the campus, off the campus, and the students apart from SCLC also can take the benefits out of such kind of international collaboration work. It's basically the aim of the international collaboration team of SCLC. So we are always headed by our principal, Dr. Kranti Deshmukh ma'am, who has always have a vision to have more international exposure to each and every students. And so we are also working on the faculty exchange, student exchange program, and soon we'll be having the student exchange program with the number of universities when the situation gets over. In continuation of the same, this year we'll be having a collaboration with the university from Italy, that is Chieti-Pescara University from Italy, the legal and the social studies department. And we're very fortunate to have also the same collaboration with the Competition Commission of India. So under the aegis and to have a celebration of Azadi Ka Amrit Mahotsav, we are coming up with this international conference on the kaleidoscopic region, specifically focusing upon the competition law and the way forward. So coming to an end, I must say that each and every participant is precious to us, each and every student precious to us, irrespective of which institution he's belonging to. And so that's why we wish to have more international, national, and local barrier-free environment we have to create, and so that we can have more development in the field of the law. Not only in the field of the law, we know that law is always an interdisciplinary approach. And so each and every discipline which is connected with the law, that we have to develop into it. So here I come to an end. We are also fortunate to have amongst us as today's chief guest, Mr. Anuj Verma sir, who is the Deputy Director of Combination Division, the Competition Commission of India, Government of India. I request Mayura Sabne ma'am to introduce our chief guest for the inauguration session. Over to you, Mayura ma'am.
Thank you, Saurabh sir. I, Assistant Professor Mayura Sabne from Shankarrao Chavan Law College, welcome you all to this 2 days international conference on the competition law. Today, we are very fortunate to have amongst us the Anuj Verma sir, who is a Deputy Director, Financial Analyst in the Competition Commission of India. Mr. Anuj Verma sir is an officer of the Competition Commission of India with over 12 plus years working experience, including 10 years of working experience in the government PSU and regulatory body. He is a qualified cost and management accountant and holds a degree in the Masters of Commerce. Currently, Mr. Anuj Verma sir is working in the combination division of the commission, which deals with the regulation of combinations, that is mergers and acquisitions under the provisions of the Competition Act 2002. During his tenure in the combination division, he has been the team member of various combination cases relating to sectors such as agrochemicals, steel and iron, private equity, automobiles, information technology, insurance and banking, financial sectors, e-commerce, digital payments, to name a few. He has been a resource person for the Indian Institute of Corporate Affairs. He likes to write on the issues relating to the public policy, corporate governance, and competition law. His latest publications include Food for Thought, Implementation of Competition Law During the COVID-19 Pandemic in the Bar and Bench. Before joining the commission, Sir has been associated with Food Corporation of India, a central public sector undertaking of the Government of India, in the capacity of Assistant General Manager. I welcome you, sir, on behalf of Marathwada Mitra Mandal Shankarrao Chavan College in collaboration with the University of Italy. Over to you, sir.
Thank you so much, Mayura ma'am. Without further delay, I request our chief guest, Anuj Verma sir, to address the gathering. Over to you, Anuj sir.
Thank you, Professor Mayura. Thank you all. Dr. Kranti Deshmukh, Principal Shankarrao Chavan Law College. Professor Fabrizio, Head, Department of Legal and Social Studies. Professor Stefano, Professor of Public Law, Department of Legal and Social Studies, University of Chieti-Pescara, Italy. Mr. Saurav, Shankarrao Chavan Law College, Pune. Distinguished panelists and participants, a very good afternoon to all of you. It is a great pleasure to address you in international conference on kaleidoscopic vision of competition law, a way forward. To start with the competition law conference, it is better to have a discussion first on what is the competition law in itself and why we need a regulatory body or a specific law for dealing with the competition matter. If I would like to define the competition, I could not find any definite definition which say that this is, you can define a competition. In a broader sense, we can say competition is a situation in a market in which firms or sellers independently strive for buyers' patronage in order to achieve a particular business objective, for example, profit, sales, or market share. Further, we have certain regulatory provisions in the Competition Acts, with the prime object of which is to regulate the market. How a competition law can regulate the market? First, we need to understand in what manner a market can be distorted. To explain that, we can have some examples. I have been informed that the past participants are mostly students and fresh lawyers. To address their concern, what is this new kind of law, or is there a new burden on the corporates for further compliance? First, we will understand why we need a competition law, and before that, what is the competition from a common person or from a layman's point of view. As you may be aware that you may be having few shops or canteen in your college campus itself. So taking an example from your college campus, if you can say you have few coffee shops in your college campus, and suppose instead of fighting on fair terms between each other, they start collaborating with each other and try to set a price which is higher than what is usually called competitive prices. So what is the direct result of that collaboration? It is the students, or we can say the consumer, who needs to pay more for the same product, which usually will be at lower price and of good quality when their firms or the shopkeepers are fighting at a fair terms. It is in a very simple manner. These are called collaboration or forming of cartel in competition law words. The direct impact is on the consumers, industry. How? Because these type of arrangement, or we can say these type of collaboration, have a direct impact on the consumer and the economy, and competition helps in efficient allocation of resources. It also helps in productive efficiency and dynamic efficiency. Why? How? Because if there is competition in the market, the firms will always try to bring some new kind of products, better quality of products at competitive prices. These will ultimately help the consumer, industry, and the economy at a large. The first example which I have given you, like collaboration between the coffee shop owners for setting the price or reducing the quantity. They will keep the same price, but they may reduce the size of cup in which they offer you coffee. This is also one of the kind of anti-competitive. Taking this example further, suppose there are only one or two coffee shops, or only a single coffee shop, and if you want to drink a coffee, you have only two options. One, you can choose the in-house coffee shop, or you have to go to up to 2 or 5 kilometers away from your college campus to have a coffee. In that case, the in-house coffee shop will have an advantage over the other participants because they are outside the relevant premises, which we may call a relevant market. This is another relevant term which you will be heard in the subsequent sessions of this program. The relevant market is important from the point of view of assessing the position of the enterprises in that market. The whole competition law, if you read and check, it will be depending on the market power in a particular relevant market. So with the simple examples, again, the single coffee shop will have to its advantage set the price. Also, certain other terms, suppose if you want to purchase your coffee, you have to compulsorily purchase a toast also or a sandwich also. Otherwise, we will not offer you a coffee. So this is why they are able to charge. In the previous example, they are setting the price, but you have choices. In this case, they are imposing a condition over to you because of their position, because there is only one option, dominance. With these two examples, I have touched upon the section 3 of Competition Act, which says about anti-competitive agreements, and section 4 of the Competition Act says about abuse of dominance position. For more details, will be discussed in the subsequent sessions. Another way of regulating the market. Why we are regulating the market? Because the market participants, as we have discussed also in the broader definition, always try to capture the market. The main purpose is to capture the more and market in terms of gaining market power. The purpose of competition law is to promote the competition among the firms. How we can do, or how before that we have to see how the market power can be acquired. Either it may be collaboration or collusion between the firms. Section 3 deals with it. Then section 4, if the firm is already dominant, it can abuse its position. The competition law does not prohibit any dominance, but abuse of that dominance, that is what is prohibited. Then subsequently, firms may go for mergers and acquisition. For that purpose, there are section 5 and 6 that deals with the regulation of combinations. So this is how the regulatory functions are mentioned. In addition to these, there is one more regulatory function which is done by the Competition Commission of India, is the competition advocacy, which means creating awareness about the competition law and imparting training on the competition law. Is the competition law is new, or it's a new age law? No, the answer is no. Competition law was there before. After independence, there was a MRTP Act, Monopoly and Restricted Trade Practice Act. Subsequently, with the development of economy, Government of India has liberalized it. And with the need of our previous law was considered as outdated or not meeting the requirement of the economy, therefore a new law was passed in 2002. That was notified or implemented in 2009. From that, substantial provision of the Competition Act was notified in 2009. And from 2011, remaining provisions, basically regulation of combination, was also notified. With these words, speaking on the importance of regulatory body, a robust competition law helps in accelerating the economic efficiency, promoting economic growth, and enhancing consumer welfare. Competition law not only ensure competition in the market, it also actively check practices that are harmful to the competition process. Despite its all-encompassing benefits, healthy competition may not emerge on its own. Therefore, a regulatory body is required which needs to intervene in the market to correct the markets, or we can say to intervene the market for oversight and necessary corrections. Successful implementation of competition policy and law largely depends on the willingness of the participants to access this. I am sure that this webinar will be useful for the students and pave way for the better understanding and career building in the competition law. With such esteemed panelists on our panel, I look forward to an interactive session, and I hope that you all benefit from this 2 days program. Thank you all. Thank you very much.
Thank you, sir, for these enlightening words. Now I will hand over further to Saurabh sir.
Yes, thank you so much, sir, for accepting our invitation, for making the collaboration with both of our institutions, and having this wonderful address. Before starting of the conference, to have an overview of the competition law is essential. And so this is what you have given to our participants, an overview or bird's eye view on the Competition Act 2002. Thank you so much, sir. We are going to hear sir again for the session. And before moving to our first session, to conclude the inaugural session, I request everyone to stop the video so that we can have the national anthem of both of the country. It is always said that in Rigveda that samani va akuti samana rudayani vaha samanamastu vo mano yatha vaha susahasati. It means let there be oneness in your resolutions, hearts and minds. Let the determination to live with mutual cooperation be firm in you all. So at the end, we can say to express our gratitude, we can say that ayam bija paro veti ganana lagu chetasam udara charitanam tu vasundhaiva kutumbakam. We always know that oneness is the Vasundhaiva Kutumbakam. With this, I now request everyone to stop their videos and will have to stand. We'll have the national anthem of Italy to be followed by the national anthem of India.
भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंग तव शुभ नाम जागे तब शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Inauguration session. We declare that the inauguration session is concluded. Now we'll be moving to our first session in next 1 minute. So I request everyone to be here. We'll be starting with the very first session of our international conference in next 1 minute. Thank you. So we welcome back you all to the first session. We have made it a little bit of an overview session over the competition law. Specifically, before moving to each and every aspect of the competition law, it is very important to know that what exactly has been given in the Competition Act of 2002. Why we are discussing this particular issue and why we have taken the competition law as the theme of our conference. And so that's why, as we know that while having the inaugural session, we already have heard from the Anuj sir that what exactly is or are the important provisions of the competition law. So apart from those important provisions, we just have to have an overview again of the Competition Act. We are here, I, Assistant Professor Saurabh from Marathwada Mitra Mandal, Shankarrao Law College, and also in charge of the international collaboration, and my colleague Mayura Sabne ma'am, Assistant Professor and the Program Officer of this international conference. Will be dealing with the Competition Act of 2002 and overview. So specifically when we talk about the competition law, if you visit the Competition Commission of India's website, you will find it out why we have come up with this particular aspect. So as it is written and been given on the website as well, the competition is the best means of ensuring that the common man or Aam Aadmi has access to the broadest range of the goods and services at the most competitive prices. As we also have heard, sir, and the example that sir has given regarding the coffee shops in the campuses. So we can very much collaborate and correlate all that particular goods and services, whatever are available in context with the lifestyle, in context with every aspect of life. We can have it, we must have it within competitive prices, but at the same time, we must have the access to it. We must have a kind of an quality to that particular thing as well. And so with increased competition in the market, the producers will have the maximum incentive to innovate and specialize. And this is an ultimate aim of having such kind of the provisions at a national and international level. As we know that when we talk about the competition law, it is not just that what we are applying it or implementing it to the Competition Act of 2002, but starting from the United Nations, starting from a number of the international organizations, we know that each and every nations also they're coming up with the antitrust law, MRTP, or laws such as like MRTP and the Competition Act as well. So this probably would result into a reduction of the cost and basically so that we can have the wider choice when you choose any kind of the product or goods or the services in the market. And so to have this fair competition in the market, we have to achieve, and we can achieve it with the help of the competition law, the Competition Act. So there are three important words when we talk about the Competition Act of 2002. The first is the competition, second is the law, and the combination of two, that is the competition law. As we know that is the basically whatever that we have discussed so far from our schooling is the competition. Okay, so in the same way or in a similar structure, we can have it in the goods and services market. So specifically in the market, we have the competition. And so to regulate that competition, what we need is the law. And so that's why we always have a jurisprudential point of view. The theory is always attached to the competition or the competition law. So basically, when we talk about the rights, when we talk about the duties, apart from that, we talk about the possession, the consumer rights. And so we know that consumer rights is also been very much evolved in more dimension. It is just not like the right of the consumer that what we thought at the time of the independence, but it is now having too many dimensions when it comes to the free market specifically, or the globalized era of the market as well. And so that's why we need to have the regulation, and regulation is not possible unless we have the law on it. Okay, so law binds each and every person to follow that particular thing, and unless we have the penalties or the penal provisions, we cannot find that the laws been implemented or laws been followed by a number of people or number of the stakeholders. And so that's why we have come up with the competition law. We know, if you understand the timeline or the evolution of the competition law, we know that prior to an independence, prior to 1947, we had a globalization or globalized market during that point of time, but the laws to regulate that particular market was specifically based on the colonial rule. The rules made by the colonies, or rules made by the then British India. And then after 1947, we had a great revolution in context with the industrialized market. And in 1956, we know that Indian industrial policies that came into existence. So post-independence, we had more focus upon the industrial policies. Meanwhile, in 1969, we have come up with the MRTP Act, which was because of the reports given by Hazari Commission report. We have Mahalanobovic's Commission report. We also have the Monopolies Inquiry Committee report, which led to the formation of the basic legal policies to regulate the competition. And so we know that in 2002, we have come up with the Competition Act. So basically, we can have the collaboration, or we can have the differences. We have to find it out between MRTP Act 69 and Competition Act, because we have studied it in that context, the evolution of the competition law. So when we have the monopolies and the restrictive trade practices, so MRTP is Monopolies and the Restrictive Trade Practices Act of 69. And at the other side, we have the Competition Act of 2002. So basically, 1901 or 1991, the prior period was having the control of this MRTP Act. This regime was controlled specifically by this MRTP Act. After 1991 reforms been carried out, and now we have the Competition Act. And as I have said, from we have the evolution from 2007, 2009 till now. We are still developing in the area of the Competition Act. When we talk about the MRTP Act, it always have the unfair practices and unfair trade practices being covered. But unfair trade practices been removed because they have to have a more elaborative, we can say, umbrella they want to put in the Competition Act. And so that's why the rule of reason approach was based as a jurisprudential base, rather we can say, for the Competition Act that we have come up with this from the 2002. So there's no competition advocacy in the MRTP Act, and we have the high importance for the competition advocacy that we are going to discuss in few of the slides as well. So this is basically we are in the developing stage when it comes to the Competition Act. Now, coming down to the objectives of the Act, you can see when you read the preamble or the starting part of the Competition Act, we'll find 4 important aspects when given as an aims and objectives: prevent, promote and sustain, protect and ensure. So what are these 4 important elements? Is to prevent the practices having the adverse effect on the competition. So whatever may be the adverse effects, we have to curb those adverse effects by or with the help of the Competition Commission or the competition laws that what we have. Laws, it means including the Competition Act, we have the rules and regulations as well. To promote and sustain. So promote and sustain the competition in the market. So no, we cannot live in the market which is having the monopolies, or we cannot live in the market where no, there is no rules and regulations to have the better control over the competition, because we know that in the absence of the competition law, we always have to face, the consumers always has to face the problems. And so that's why we have to promote and we have to sustain as well. Okay, so sustainability of the competition is important to have more economic growth and development in the market. Then we also have to protect the interest of the consumers, because we know that each and every individual in the in this conference, we know that no, when you wake up in the morning and when you go to the bed, each and every point, no, you are no at each and every point of time you are the consumer of the products and the services. So when you go to the sleep, also you are the you are the person who are taking or consuming some kind of thing. So for example, if you consider the air condition or the ceiling fan or number of factors, okay, so you are the consumer, so at all the point of time. And so that's why we need to have the protection of the consumers when it comes to specifically the competition in the market. The lastly is to ensure the freedom of trade carried on by other participants in the market in India. Okay, so basically we can as we know that we have to choose perfectly the perfect thing for us. And so when you have to choose these particular things, you need to have the quality, the quantity, you need to have an access. Then it also leads to the fair advertisements as well. And so all that also have its connection with the Competition Act. And so that's why with these objectives, we have come up with the Competition Act in 2002. So this act specifically deals with the 4 major aspects: the anti-competitive agreements, the abuse of the dominance, the combination regulation, and the competition advocacy. And so the act is having the 9 chapters specifically dealing with these 4 objectives that we have talked in a previous slide. So specifically, chapter 1 deals with the preliminary approach of the Competition Act. Section 1 deals with the short title, extent, and the commencement, and section 2 deals with the definition. As sir has rightly pointed out, that important definitions which are there in section 2, specifically cartel and the relevant market, the relevant geographical market, enterprise, goods, the relevant product market, the service, the shares, etc. So whenever or whatever maybe the words that come in into that particular the Competition Act, we have the explanation, we can find it, and the definition, we can find it in the section 2 of the Act. Okay. Moving ahead, the basic structure of the competition law in India, section 3, 4, 5, and 6. So over to you, Mayura ma'am.
Thank you, Saurabh sir, for a very nice background of having the competition law. While we have studied the aims and objectives of having the competition law, now let's look after the substantial as well as procedural part of the competition law. So when I say the substantial part, whatever sir has discussed earlier, that the anti-competitive agreements, abuse of dominance, and regulating the combinations. So this is the basic structure of the competition law which is existing in India in the form of the Competition Act of 2003. In section 3, if you see, the nature of section 3 is such that it includes all types of agreements which inclusive of all stages for the provision of goods and services, starting from the manufacturer till it reaches to the consumer. So the slide is not visible. Yes, now I can see it. So it includes all stages with respect to the provisions of the goods and services. And I won't be going into too much detail of all these sections. The reason being that each and every session of this 2 days international conference has been targeted around these 3 sections only, because this is the basic crux of the Indian competition law. As Anush sir has already pointed out, section 3 deals with the anti-competitive agreements, and anti-competitive agreements can be the horizontal agreements as well as vertical agreements. And as Saurabh sir has pointed out, the whole approach of the competition law is pro-competitive in nature. That means it never talks about restraining competition. It talks about regulating competition in a very healthy competitive environment. So that's why we have accepted the basis as the rule of reason. And these all things are visible from the all provisions of section 3, section 4, section 5, and section 6. Section 3 also includes within itself tie-in arrangement, just like the Anuj Verma sir has already given an example that if you want to have a copy, you need to have a sandwich along with it. So this is a tie-in agreement where a party, a consumer, has to pay for the goods for which he is actually not willing. And this is actually having the adverse impact on the competition along with the consumer. This is how the competition law deals with the practical realities of the common man's life. Then exclusive supply agreement, exclusive distribution agreement, refusal to deal, and resale price maintenance. So these are the different terminologies which are also covered under the anti-competitive agreements, with which later on we will be dealing with another sessions. Then section 4 talks about abuse of dominance. Herein we need to take into consideration that dominance is not restricted. A party, a competitive player can be dominant in the market, but when it started abusing its dominance, then the role of competition law comes into picture. Just for a simple example, that when the BCCI start abusing its dominance, then only the role of competition law will come into picture. Unless and until BCCI is regulating the cricket academy in a very good manner, there is no role of a competition law to be played. So this is a very innovative feature and a very good feature which we have adopted from other international perspectives. Section 4 also includes within itself predatory pricing and the concept of relevant market, which sir now just have discussed in the definition section, is very much important in understanding what do you mean by abuse of dominance. Then the next section, section 5, talks about the combinations. Combinations are not new. They were already regulated by the Indian Companies Act 2013, that is already 1956 Act. They are nothing but the mergers and amalgamations. But when such mergers and amalgamations were having certain kinds of impact upon the competition within India and outside India, then an innovative approach was needed to regulate them in a different competitive perspective. And from that pro-competitive approach, this section 5 has been included into the competition law. Section 6 talks about pre-combination scrutiny. So these are the very different angles when we talk about mergers and amalgamation. Here also the pro-competitive approach of the competition law is reflected. Next. Over to you, Saurabh sir.
So Chapter 3 of the Competition Commission Act, the Competition Act of 2002 deals with the Competition Commission of India. So to whom we are collaborating to have this international conference. Section 7 to 17, it deals with the Competition Commission of India. So Competition Commission of India, CCI, was established by the central government with effect from 14th October 2003. And CCI consists of the chairperson and the 6 members appointed by the central government. Specifically, the Competition Commission of India, the Chapter 3 deals with the establishment of the commission, the composition of the commission, that is the chairperson and the other members, the selection committee, the term of the office, the resignation, removal, suspension, the restriction on the employment, the administrative powers, the salary and the allowances, and specifically the most important, the vacancy or the other related reasons cannot be considered as invalid reasons for the proceedings of the commission. So they are invalidate, not to invalidate the proceedings of the commission. And the other appointments are also discussed in this particular chapter. If you see the organogram of the commission, below the commission, you can see the secretary, the general, the director general, and the advisors. So secretary is the secretariat, the HR, the finance, and the service division. In the advisory advisors, we have the advocacy division, economics division, the antitrust division, the combination division, the legal division, international cooperation division, and the capacity building division as well. Moving to duties and the powers. Over to you, ma'am.
Thank you, sir. So after seeing the basic structure of the Competition Commission of India, let's talk about what kind of powers it enjoys and what kind of duties it is entrusted with. So first of all, when we talked about the substantial part, that is section 3, section 4, section 5, and section 6, they are actually talking about that how the competitive market works. But how the Competition Commission regulates, that is given into the duties and powers. So under section 19, the Competition Commission of India can perform inquiry into certain types of agreements which are anti-competitive in nature, and it can also inquire whether a dominant position is being abused by a particular enterprise or not. Then it goes into inquiry into combinations. So this is a very different perspective than the company law, because in company law, the compliance part of the mergers and acquisitions has been dealt with. But in this part, if the combination is having appreciable adverse effect upon the competition within India, then it can become void under the powers which are granted to the Competition Commission of India. So this is a very grave and significant power which is enjoyed by the Competition Commission of India, because nowadays we see that in order to sustain, to survive into the markets, many small players are getting into mergers and acquisitions. And when these small players are becoming big players, they should not harm the competitive spirit of the small players. So here the Competition Commission of India plays a very significant role. Then the third important power or duty, it can be a both, that it decides on the reference. The reference can be taken care of suo motu, or it can be given by any kind of the central government authority. So herein the reference opinion is given by the Competition Commission of India. Another important aspect of this Competition Commission of India is that it is having extraterritorial reach. So whenever any activity which is done by any of the market players outside the boundaries of India is having significant adverse impact upon the competition within India, Competition Commission of India can take a cognizance of it, and it can exercise those powers in an extraterritorial manner. This is a very important power which is enjoyed by the Competition Commission of India in this globalized context. Then another two important things which can be done by the Competition Commission of India, which is the procedural part actually, it can issue interim orders, so that till the matter is decided finally by the Competition Commission of India, the adverse effect upon the competition can be held off for a time being, and it can investigate into the contraventions. Suppose the combination has been regulated by the Competition Commission of India upon terms and conditions, and if the enterprises is contravening these kind of things, then the orders can be penalized. So these are the multifarious powers and duties which are enjoyed by the Competition Commission of India, and it gives teeth to the existence of the Competition Commission of India. Over to you, sir.
So chapter 6, it deals with the penalties. So we know that unless we have the penalties, the laws are inactive, rather we can say so. So that's why we have specifically the chapter has been made in the penalties. So contravention of the orders given by the commission, the compensation in case of the contraventions of the orders of the commission, we have the penal provisions. Now, penalty is also is given at the time when it's a failure to comply with the directions of the Commission and the Director General of the Competition Commission of India. The power is there to impose the penalty for non-furnishing of the information on the combinations, as we have discussed in a previous slides as well. We also have the penalty for making the false statement or omission to furnish the material information as well. We also know that these kind of the penalties are just not the normal penalties like what we have with the other civil laws, but we have it specifically per day. We can also have the increasing of the penalty. We can say the price as well. So when it comes to the other penalties, we also have the penalty for the offense in relation to the furnishing of the information, the power to impose the lesser penalties also with the Commission, crediting sums realized by the way of the penalties to Consolidated Fund of India, and lastly, the contributions by the companies and what we have to do when such kind of the things are happening in context with the competition law. Moving ahead to the competition advocacy, over to you, ma'am.
Thank you, sir. Apart from the substantial provisions and the procedural part, which we have already seen, this is one of the unique features of having the competition law in India. That is the competition advocacy. Law always emerges out of policy. But in context of India, there is no such kind of a competition policy which is existing. So the competition law which we are having overview right now, it is the best combination of having a law and policy together. Now, why we need to have a competition advocacy herein? There is a very good example of this, because there are certain laws which were already existing when this competition law was brought into force. That is, IPRs were already there, labor laws were already there, Consumer Protection Act is already there. So in order to fit into this puzzle of multiple laws, competition advocacy is a sine qua non for the existence of the competition law in India. Now, this competition advocacy is nothing but creating awareness about having a good competition, how the Competition Commission regulates competition within India and outside India, and how it is benefiting the common man like you and me. So for promoting competition advocacy, there are three ways which are adopted by the Competition Commission of India. It actually produces advocacy booklet. It is updated according to the needs of the time. And when it is updated, the whole contemporary trends which are going on with respect to the competition in India and outside India, they are reached to the common masses like you and me. Then it creates awareness by conducting various guest lecture series in online as well as in offline mode. And along with that, it imparts training to the various stakeholders. So this collaborative approach with the Competition Commission of India is an outcome of this competition advocacy, which is adopted by the Indian competition law under Chapter 7th. Next. Yes, apart from having these two unique features, the third important feature is that the National Company Law Appellate Tribunal, which is constituted under Section 410 of the Companies Act 2013, it acts as an appellate body over the Competition Commission of India under Section 53A. So the rule which is settled down by the Competition Commission of India is not the final one. There is always a chance to file an appeal to NCALT. And if you're not satisfied with the decision of this appellate tribunal, you can always approach to the Supreme Court of India. So Supreme Court of India is the final authority for deciding the matters which are related to the competition. So this is the hierarchy of the appellate mechanism which has been devised into the competition law of India. While deciding appeals, two powers can be enjoyed by these appellate tribunals. First, it can award the compensation. For example, if due to the decision of the Competition Commission of India, any of the stakeholders has faced any kind of adverse impact in terms of a monetary loss, that can be compensated very well. And secondly, another thing which can be done, that the power, if the person is not following the orders of the Competition Commission of India, Appellate Tribunal, or the Supreme Court, there is always a power which is given to all of these three to punish for the contempt. It is very important in order to have proper and effective implementation of all these provisions of the competition law. Next. Yes, and to the last of this whole presentation, these are certain miscellaneous points, but very important ones, because central government has a very definitive role to play while the Competition Commission of India regulates and implements this whole competition law. So central government can grant exemption to certain enterprises from the application of this competition law. It is not on the wish and will of the central government. They also have to follow the procedure which has been given under the Indian competition law. Central government can also issue directions to the Competition Commission of India for its effective and proper functioning. And in certain matters which are listed down explicitly into the competition law, central government can supersede the decisions of the Competition Commission of India. So central government has given an overpowering hold over the Competition Commission of India. But it is kind of a collaborative venture when they both have the objective of regulating and promoting competition within India. So if we need to conclude in a nutshell, the whole Competition Act is complementary and supplementary to the existing laws. It nowhere says that it will be contrary to any kind of laws. If you read the miscellaneous chapter, you will find that though it has been given overriding effect, it has tried to achieve that complementary nature, like in terms it has given exemptions to IPR. So it is nowhere contravening the IPR regime which was already existing in India. Actually, it is an attempt to supplement it and to promote the IPR within India. It also restricts the disclosure of information which is received by the enterprises. So it actually follows the fundamental right to privacy in its whole context and still its origin. And the Competition Commission of India excludes the jurisdiction of the civil courts so that whatever matters are decided by the Competition Commission of India will get authenticity, validity, and they do not get entangled into this tedious judicial procedure, and the whole objective of having this competition law is achieved. So this is all about the competition law. Now I will hand over to Saurabh sir.
Yes, thank you, Mayura ma'am. So this is an overall view of the Competition Act. So again, as ma'am already said that it is complementary and supplementary. So nowhere we are going to study the competition law in isolation, or it is just not an it's a watertight compartment. It is just not like that. So it is where we like law is an interdisciplinary, and so that's why we are going to deal the Competition Act as well in an interdisciplinary manner. So it deals with the intellectual properties and number of the important we can say dimensions. And so that's why we have organized this particular conference, so that apart from the Competition Act of 2002, we can have the number of approaches to be discussed by the stalwarts in the competition law. So that's why we have the Anuj Verma sir, who is going to have, who's going to take the second session on the regulating the combination under the competition law of India and the contemporary issues and the challenges. We're also having today the session 3 by Manmohan Sharma on the emerging competition issues in e-commerce in India. So again, a different aspect that we are going to take with this. And today will be coming at the end or the last, we can say, segment of today's international conferences with the panel discussion by the competition law practitioners, Advocate Ketan and Advocate Devansh are going to discuss about the contemporary issues and the challenges in a practical aspect of the competition law. So this is a kind of an kickstart to our international conference and a kaleidoscopic vision of the competition law in national and international perspective. Tomorrow we'll be having the session by Professor Kondiya on the legal framework work of the digital markets and the products. So again, a different aspect and the dimension of the competition law. Then we'll be having Professor Anand Kumar Singh, who will be talking about the arbitrability of the competition law disputes, specifically focusing on Indian structure. We'll be having tomorrow also Ilaria Ottaviano ma'am from the Department of Legal Studies, Legal and Social Studies of the University of Chieti-Pescara, Italy, who will be talking on the recent developments about the European Union's antitrust law. And then we'll be having Mr. Shekhar's speech, who is the chief guest for the valedictory session as well, on the compliance of the antitrust law in India and overview. So this is a kind of an overview of the Competition Act and the international conference and a bird eye view on all these phenomena. So I thank everyone for patiently listening to so far the inaugural function and the session, the first session on the competition law. Now I request each and everyone to just feel the international conference, the feedback form for the first session, and then we'll be breaking for the lunch, and then we'll be meeting at 2:30 with Mr. Anuj sir's lecture session, which will start sharply by 2:30, which will be the second session of the conference. So I'm just posting the feedback form in the chat window. Okay. So thank you, everyone. See you at 2:30 sharp. Thank you.
Thank you. Good afternoon, one and all. We will start with the session within 1 minute. Welcome back once again to this 2 days international conference organized by Marathwada Mitra Mandal Shankarrao Chavan Law College, Pune, in collaboration with Department of Legal and Social Studies, University of Chieti-Pescara, under the aegis of Competition Commission of India. Hereby, today we are celebrating Azadi Ka Amrit Mahotsav, and we have organized this conference on the topic of kaleidoscopic vision of competition law, a way forward. Today, we are going to start with our second session of the day. For this session, we are fortunate to have with us Mr. Anuj Verma sir, who is a Deputy Director, Financial Analyst, and who is associated with the Combination Division of the Competition Commission of India. With having more than 12 years of experience in the government field, we are fortunate to have sir to enlighten us on the topic of regulating combinations under the competition law of India, contemporary issues and challenges. So without wasting further time, I would like to have Anuj sir enlighten us with his words of expertise. Over to you, Anuj sir.
Thank you, Mayuria. I want to share my PPT. Is this visible to all?
Yes, sir, it is visible.
Should we start or wait 1 or 2 minutes?
Yes, sir, we can start. Participants are joining.
Okay. Welcome to all again. This session basically pertains to the regulation of combinations under the Competition Act. Before we start, let's discuss why the firms do mergers and acquisition and why there is a need to assess these mergers prior to consummation. The basic reason for any M&A deal may be some pro-competitive and few may be anti-competitive. In terms of pro-competitive concerns, the reason for doing any M&A may be of economics of size and scale, economies of vertical integration, complementary resources, and the firm may have some surplus fund for investment, and or the industry is also going toward the consolidation. These may be the reasons for which firms go for mergers and acquisitions. But sometimes these amendment may raise certain competition concerns, which may result in accumulation and exercise of market power. The first session overview of Competition Act was very well presented by the presenters. They have covered all the aspects of competition law in a very brief manner. In that session, we have seen that there is already a provision for reviewing anti-competitive agreements under Section 3 and abuse of dominant position under Section 4. When we already have these two provisions, why there is another provision which deals with regulation of combination. If there is any concern of acquisition of market power by the parties pursuant to any transaction, then they can be easily caught by the commission under Section 3 or Section 4. But still we have Section 5 and 6. So there are certain reasons which makes it mandatory as a part of Competition Act itself that certain transactions may be requiring a review by the commission at prior to its happening at ex ante. As we know that mergers sometimes may lead to monopoly or near to monopoly situation and likely to be prohibited by the Competition Act. But if that happens after consummation of a transaction or after closing of a transaction, what it may result? The result of it is in the form of cost of remedies. Once a deal is completed, it involves a lot of cost and time and resources of the state as well as of the parties. After the consummation of any transaction, if any regulatory body goes into unscrambling of these transactions or go after investigation, it is completed, then this may result in a lot of inconvenience to the parties to the transaction, as well as it may result in cost of remedies, uncertainties for the parties, and preventing future abuses can be done at before the happening of transaction in a better manner than to find out that this firm has become dominant and it's abusing its position. Further, the purpose of Competition Act is to maintain a competitive markets. Second, always exclusive reliance on ex post control is not always effective. Therefore, because of these reasons, ex ante assessment of any transaction is done. As we have seen that ex ante assessment is required, therefore, what is done during the assessment of any transaction is futuristic. Everything is presumed on the basis of information available at present that what will be the future course of action or what will be the impact of this transaction in the market. To explain it in a very simple manner with the help of this example, it will be very easy and it will clear the impact of any combination. In pre-merger stage, there are two suppliers as we can see in the slide. One offer buy my product for ₹100 and take 1 year service free. The second option, the seller give options to the customers, buy my product for ₹98 and take 6 months of service free. Now the customer has a choice. The competition is benefiting the customer at this present stage. Suppose these two firms go for merger, and after this merger, what will be the situation in the market? The only firm which is remaining after this merger will offer now you can buy my product at ₹102 with no free services. In this manner, in this conduct after this transaction, customer has no choice and it's adversely said to be affected by the combination. So this is the simplest way of presenting how a merger transaction can affect the consumer, can affect the market. Post this transaction, it is one of the sure fact is that the number of suppliers reduced and the customers are left with few choices. But if these combinations are likely to raise the competition in the market or likely to benefit the consumer, then they are said to be the pro-competitive. Now we can say that the competition is likely to affect consumer economic society in the following manner. Consumer has more choice at competitive prices with quality of products. In the overall economy, that with the allocation efficiency, productivity growth also grow and wealth create. For the society, it's innovation, welfare, and aspirations. From this slides onwards, after discussing some basics about the combinations under competition law, we comes to the legal provisions of the combination mentioned in the Competition Act. Along with the discussions on the legal provision, we will be discussing with practical implication how we are actually implementing these and what the difficulty can be found. From a lawyer's point of view, these are the very important points which we are going to discuss. Since this involves the identification of transaction for the purpose of Competition Act, whether this transaction is notifiable or not. The first step in any transaction for starting a process under the Competition Act is to identify whether this transactions cover under the combination or not. Most of the times, it is not as much clear as we think that this transaction may be notifiable to the Commission. Therefore, from that point of view, proper understanding and in what circumstances it will be notifiable to the Commission is very important. Section 5 of the Competition Act define what is combination for the purpose of Competition Act. To simplify it, an acquisition, which again means a different transaction, which we'll be discussing subsequent slides, merger or amalgamation, which meets the relevant assets or turnover thresholds. In this section, already has been highlighted is relevant assets and turnover. It means not all transactions are notifiable, only those transactions which meets the relevant assets or turnover criteria as stipulated under the Competition Act are notifiable as combination. Section 5 only define what is combination. Section 6 lays down the circumstances on which parties are required to notify. Section 6 prohibits no person or enterprise shall enter into a combination which cause or is likely to cause an appreciable adverse effect on competition within the relevant market in India, and such a combination shall be void. This section also places the combination that does not qualify for any exemption or meet the thresholds provided in the Section 5 required to file a notice and get approval from CCI before they can be implemented. It means the filing of notice under the Competition Act of any combination is compulsory. There is no voluntary regime in India. It is mandatory regime that once a transaction is a combination, it has to be filed with the Commission unless it is exempted by way of any regulation or notification from central government. This has to be done and approved by the Commission before implementation. Implementation include any part of the transaction also. If a transaction happening in a number of steps, then you cannot implement even one step before approval of the Commission. Section 6 also provides that no combination shall come into effect until this is the overall timeline for processing of a combination, 210 days from the day on which notice was given to the Commission or Commission pass an order. So once the notice is filed with the Commission, from that day till 210 days or passing of order by the Commission under Section 31. This is the overall time period of Section 6, which says that any combination has to wait till 210 days or approved by the Commission, whichever is earlier. If you read the language of Section 5 from the Act, it's a very lengthy language, the provision. To simplify that language, the assets and turnover criteria as per the recent notification is mentioned in this threshold table. The thresholds has been defined at two levels, at enterprise level and group level. Once any transaction happen, and if that transactions involve an acquisition or merger or amalgamation, the next step is to identify the assets and turnover of the parties to the combination. The combined assets of parties in India is more than 2000 crore or either of these two has to be met before when we say the thresholds are met. If any one of these are met, then the parties transaction are called combination. Combined turnover is 6000 crore. If they are worldwide, operations are worldwide, the parties to the combination has worldwide operations, Then the criteria is $1 billion with at least 1,000 crore in India for combined assets, $3 billion with at least 3,000 crore in India. These thresholds are at enterprise level. For enterprises having presence in India or with global presence having one leg in India. If suppose the enterprise belongs to a group and at enterprise level, the both either the assets criteria or turnover criteria is not met by the parties, then next level is to identify the assets or turnover criteria at group level to which the parties are belong. At group level, if in India the assets are more than 8,000 crore or the turnover is more than 24,000 crore, if the operations of group are in India, but if the group has worldwide presence, the assets of that group is more than $4 billion with at least 1,000 crore in India, or turnover more than $12 billion with at least 3,000 crore in India. So these are the thresholds which are very high, or we can say one of the highest thresholds in the world. If we compare the competition jurisprudence worldwide, India is having the highest number of thresholds in terms of assets and turnover. All the purpose is to identify, but the purpose is to notify only the big transaction, not the small one, because the big transactions are more likely to have impact on the competition in India rather than the small one. But it may also happen sometimes that a big enterprise with enterprise level alone meets the enterprise level thresholds. And if they make any acquisition of any size, it becomes notifiable. Therefore, the government by way of notification has introduced a de minimis exemption. In this exemption, again, the criteria is of assets or turnover, but that applies only to the target or merged enterprise. If the target assets is less than 350 crore or turnover is less than 1,000 crore, then the transaction is not notifiable irrespective of the assets and turnover of the acquirer. To clarify it further, if suppose a company having assets of more than 2,000 crore and turnover of more than 6,000 crore, it is making an acquisition of enterprise B whose assets are less than 350 crore, but its turnover is more than 1,000 crore. In this case, if we apply the de minimis criteria on target B, then since its assets are less than 350 crore, therefore it will get the benefit of exemption, de minimis exemption. But at the same time, if de minimis exemption is not available and acquirer and target meets any of the assets of turnover criteria, then transaction becomes notifiable. In this way, de minimis is a both way, allow exemption and both way. If and target meets assets or turnover criteria is less than 350 crore or 1,000 crore in India, then it's completely exempted from the combination. And at the same time, if it does not avail any of these de minimis exemption criteria, but it meet the thresholds of any assets or turnover, the transaction becomes notifiable. I hope this is clear. Then what is notifiable? If we read the language, it says acquisition, merger, amalgamation are notifiable. But the definition of acquisition has been provided in the Competition Act, which include acquisition directly or indirectly of shares, voting rights, assets, control. Control is again a very substantive term which include positive control, negative control, direct, indirect, joint control, sole control, and again it has to be decided on the case-to-case basis. It is, and we cannot say a simple definition fit for all. We have to infer this control from the past decision of the Commission and Competition Act. Sometimes Companies Act also been referred in the Competition Act. In other than acquisition, demergers are also notifiable. Joint ventures are notifiable. Mergers and amalgamations notifiable. Interconnected transactions. What is these interconnected transactions? In a corporate merger scheme, it is not straightforward that you go and merge with the company. Sometimes the scheme itself involves a number of steps. which require the party first will do a demerger, then a new company will be created, then they will invite some acquirer in that demerger, then the acquirer will also invest some of its assets in the demerged company. It may, in this way, it may involve a number of steps. If in any transaction, a number of steps are involved, then we need to look at the substance of the transaction, what the transaction want to achieve. And if this become a combination, all the steps together filed in a single notice and analyzed separately. For this, we refer regulation 9.4 and 9.5 under the combination regulations. Combinations. After reviewing the notifiability and combinations, there are certain statutory exemptions provided under the Act itself and by way of combination regulations. Once a transaction is notifiable and is a combination, we have to check whether the transaction can avail any of the statutory exemptions or exemptions provided under the combination regulations. First is section 6.4. Section 6 of the Competition Act gives some mandate that the parties to the combination has to notify. The section 6.4 of that section itself provide an exemption that acquisition by public financial institutions, bank, venture capital fund, foreign institutional investor pursuant to an investment agreement or a loan agreement are excluded from the provision of section 6.2. So transaction by these institutions are exempted by way of section 6.4. However, they have to give a post facto intimation that the transaction has happened. In addition to statutory exemption, section 54 of the Act empowers central government to exempt certain category of enterprises from the purview of Competition Act. In exercise of this power, the central government has issued certain notifications exempting certain category of enterprises, which include regional rural bank, banking companies, public sector oil companies. In addition to section 54, combination regulations, the CCI has been empowered to make regulation for the purpose of discharge of its function under the Competition Act. By way of getting this power, the CCI has notified combination regulation. These combination regulation contain Schedule 1, which specifies certain category of transactions. These transactions are normally not notifiable to the Commission. Therefore, we have kept that in the exemption category. We will be discussing it later. In addition to exemption, the target exemption, which we have discussed in previous slide, acquisition where the target enterprise has either assets in India of less than 350 crore or turnover of less than 1000 crore are exempted from the provision of Competition Act. Combination regulation exemptions. These are the certain exemptions. Few exemptions we have written in the slide. These are the combinations by way of Competition Act. But as per the combination regulations, Commission has considered that these transactions normally not require a notice to the Commission because these are not likely to raise any competition concern. Therefore, by way of combination regulation, Commission indirectly has granted exemption to these category of transactions. What are these categories? These include acquisition of less than 25% of share and not leading to control, or less than 10% acquisition of shares solely for the purpose of investment or in ordinary course of business. If you are already holding 25% or more but does not hold 50%, then additional acquisition of shares which may not result in sole or joint control by the acquirer or its group. All the acquisition were already holding 50% or more, except additional acquisition does not lead from joint to sole control. Some intra-group transactions, if any transaction is happening intra-group, then it is not notifiable. If any transactions related to stock in trade, raw material, stores, spares, then these are also not notifiable because these are the ordinary happening in ordinary course of business, and therefore no separate notice is required to be filed in respect of these transactions. So we have discussed some main exemptions. Now, if we can summarize our process till this stage, what we have seen that we have to see for each transaction, is it an acquisition, merger or amalgamation? If the answer is yes, we will go to the next step. Is it excluded or exempted in terms of the Competition Act? If the answer is no, then we go to the next step. Are the notification thresholds exceed the threshold which we have discussed earlier? If the answer is yes, then the transaction is notified. Even after having going through all the provisions of the Competition Act till now, it may happen that there may be certain doubts about the parties or doubts in relation to the interpretation of provisions of Act in the legal team or legal counsels or even the parties. So Commission has provided certain facility to directly discuss with the officers of the Commission on an informal basis, which is called pre-filing consultation for notices. Pre-filing consultation can be sought by the parties for the purpose of identifying the information, for filing complete and correct form, for identifying additional information in case parties feel certain additional information may be required by the Commission. They may come and contact with the Commission's officer, identifying any other key issues, or if they have any interpretation whether this may be considered as controlled by the Commission or not, or this transaction is notifiable or not, in what form we should notify. Any parties to the combination or legal firm representing the parties may come and discuss with the officers of the Commission on an informal basis, which is not binding on the Commission. Parties may take a call at their end. In addition to this pre-filing consultation facility, there is a software also, do-it-yourself software available on the website of the Commission. Parties can use this software to identify whether their transaction is notifiable or not. No fees is charged for any pre-filing consultation or using of this software. It is available free of cost. Now, receipt of the notice. Parties has option to file notice in Form 1 or Form 2. However, combination regulation has provided certain criteria in what circumstances they need to file Form 2. Form 1 is a short form and default form. The filing fees is 20 lakh for Form 1 and 20. Just a minute. Yeah, parties may file Form 1, which is a short form and default form. Parties at their option may file in Form 2, but usually parties are required to file in Form 2 if the horizontal overlap in the relevant market after combined market share is more than 15% and vertical relationship combined market share is more than 25%. However, as per Regulation 5.5, the Commission may also give directions to the parties to file in Form 2 to form a prima facie opinion. What is horizontal overlap and what is vertical relationship? I think you have some idea now. If what parties, the merging parties or parties to the combination are playing in the same market, that in that case, they are said to be placed in the horizontal overlap. If the parties to the combination are placed in the upstream and downstream, means in the part of same supply chain, then they are said to be in the vertical relationship. In this context, if their combined market share in that relevant market is more than 15%, or in vertical relationship, if their market share is more than 25%, then parties has to come in Form 2 with the filing fees of 65 lakh. But again, parties at this stage has at their option may file. However, and as per Regulation 5.5, Commission may also give directions to the parties to file in Form 2. In addition to Form 1 and Form 2, there is Form 3 also. During previous slides, we have discussed that there is certain transaction by public financial institution, which normally not required to be filed with the Commission. However, an intimation post consummation is to be given to the Commission. For that purpose, they have to file Form 3. Total 3 forms are used in combination regulation. Green channel filing. Recently, the Competition Commission of India has introduced a green channel combination regulation 5A. It's a new initiative and it is in the direction of ease of doing business. Further, as you know that the India is a mandatory regime. Parties has to file and wait till the approval of the commission before they consummate this transaction. By way of introduction of green channel filing, the commission has enabled a system which grant approval instantly once the notice is filed. How? That we will be discussing. Parties to a combination may at their option give notice in form 1. The transaction is applicable only for form 1. When parties do not provide or produce or identical or substitutable product or services, do not engage in any activity relating which are at different stages or level of production, and do not engage in any activity relating which are complementary to each other, which means there should not be any horizontal overlap, there should not be any vertical relationship or complementary products to each other. If there is no overlap between them, they can file form 1. Upon filing of a notice and acknowledgement thereof, the proposed combination deemed to have been approved by the commission. In case after filing of this notice, it is found that the transaction was not covered under regulation 5A, the filing will be treated as void ab initio. It means no notice has been filed with the commission and commission will proceed accordingly. This is one of the recent introduced regulation and very important point from the point of view of seeking approval of combination. Your queries are welcome. If at any stage you think that you have any question or doubt, you are free to ask, or we can take up in the end of this presentation. Non-filing of notice. After discussing the filing requirement and the process, what will happen if no notice was filed with the commission? As section 5 and 6 are mandatory in nature, and the combination or filing of combination are mandatory and suspensory in its nature, which means that once a combination is notifiable, it has to be notified and commission's approval is required. If parties fail to file the notice with the commission, penalty proceedings will follow. Section 6 of section 2A makes it mandatory to stand still obligations, which means after filing of notice, parties cannot consummate any part of the transactions even, and they have to wait till 210 days or approval by the commission. If they proceed in contravention of section 6(2), the parties will be liable to penalty. Non-compliance, penalty for non-compliance has been provided in section 43A, which is up to 1% of assets or turnover. From a lawyer point of view, it is very necessary to check the compliance part, because nowadays regulatory compliances are very serious. Penalty amount may not be pinching to the parties, but the name of that penalty, that they have been penalized for contravention of that, is very harmful to their image. Therefore, a number of companies are taking it very seriously, and the commission is also facilitating, in case you have any doubt regarding the applicability of competition provisions of combination to your transaction, you feel free to come to the commission, seek an informal consultancy with the officers of the commission, and you can then decide. Inquiry upon its own knowledge. Then the question comes, how commission will come to know whether this transaction has happened and not been notified to the commission. For that, what we are doing in the commission, on a monthly basis, we are scrutinizing all the transactions from different sources, which has happened in India or announced in India, that these transactions are going on. A monthly basis, we are doing this exercise. We scrutinize, we prepare a final list, and we are sending regularly letters under section 21, which means inquiry on its own knowledge or information by the commission. We seek certain information whether this transaction was in relation to the transaction, and then if find that the transaction was notifiable and has not been notified to the commission, other proceedings will also go. Process after receipt of notice. This is the internal processing. The outside part, legal part, non-compliance part we have discussed. Now the internal processing of any notice which is filed with the commission. After filing of notice, what will happen to the notice? Parties are not aware of that. Parties file and wait till the approval of the commission. But during the process of that notice, commission may communicate with them by way of formal letters. So this process which we are going to discuss is the internal process of notice in the commission. Notice may be received in the form 1 or form 2 as the case may be. The same is allotted to a case team. What is case team? Case team basically how the division work or how the commission work. Commission is divided in different divisions as we have discussed earlier in session 1. Each division is headed by one advisor. That is was also discussed. Each division headed by the advisor consists of different case teams. These case teams consist of officers from different cadre. They are from lawyers, finance, and economists. So after allotment to a case team, what the case team do? Case team scrutinize the notice from the point of view of information requirement. If case team finds that there are certain deficiency in the notice, certain information gaps are there, they simply issue a letter which is we called as defect letter, and in other jurisdiction it is called request for information, RFI, under regulation 14. Further, in addition to deficiency in the information, certain additional information is required. Then under regulation 5.4, commission may ask the same. Commission may also ask additional information from the third party who are not parties to the combination. In what cases? Basically, if suppose certain transactions require involvement of a different regulatory body or other market players, and the transaction is very significant. In that case, before forming a prima facie opinion, commission may ask third party also to provide their inputs for the purpose of taking an opinion. After all the information is received, commission has to form a prima facie opinion under regulation 19.1. What can happen if there is no competition concern? Commission can decide that there is no AEC in regulation 19.1, but suppose commission decide that on the basis of information available at prima facie stage, there are AEC concerns. Then commission will proceed further. But after forming of prima facie opinion, commission proceed further. Parties may also be having the same information because all the information provided by the parties in the notice. And when they file the notice, they also have some idea whether this transaction may raise competition concern or not. Therefore, there is an enabling regulation 19.2 which allow the parties to the combination to provide modification to the proposal at the prima facie stage itself, so that time of parties can be saved. At this stage, before the commission forms prima facie opinion, parties to the combination may come at their own with the remedy proposal. What is remedy proposal? It is not prudent always to block a transaction which raises competition concern. So in case of any transaction, competition concerns are found, then commission may either block it or allow it with modification. These modifications may come from the parties or from the commission. At this stage, when the commission is forming its prima facie opinion, parties at their option can provide voluntary remedy proposal under regulation 19.2, so that if there are any concern, can be removed at this stage and approval can be granted at this stage. However, if parties do not come with a remedy proposal and commission finds that the transaction is likely to have an appreciable adverse effect on competition, commission will deal with accordingly. Now the scheme of review legal provisions. Commission decides that there is no AEC, commission combination is approved and order is passed under section 31.1. Scheme of review legal provision. Commission decides that the combination may raise concern of appreciable adverse effect on competition. Then commission will issue a show cause notice to the parties to be responded within 30 days. receipt of response, Commission may call a report of Director General for providing its input, or Commission may proceed with the case at its own. Commission has to form again a prima facie opinion after receipt of response from the parties and DG report or other material on record. And again, if Commission find that there is competition concern, then proceeding will start. If they, after receipt of response to so-called notice, there is no competition concern, Commission may approve the transaction. In second case, when there is competition concerns, Commission give directions to the parties to publish the details of notice in 4 national newspapers. Within 7 days, the directions will be issued, and in 10 working days, parties has to publish within 10 working days of these directions. The purpose of publishing the information of any combination is to invite the comment of public. Anyone from general public or enterprise competitor, anyone, if they feel that the proposed combination is likely to impact market negatively or them, they can submit their observation or comments to the Commission within 15 days, and Commission, after receipt of response from all the parties public, will decide accordingly. Then final order, after receiving all this information and comments and other information which may be sought by the Commission after receipt of comment from public, from the parties, the Commission may approve the combination in case it is not likely to have any competition concern. Commission may direct that the combination shall not take effect if it is likely to result in combination, and Commission may also approve with the modification. The modification process is again defined in the section 31 and subsections. So scheme of modification. First, the modification. Commission may propose appropriate modification. Previously, it was the parties who has to suggest a modification or submit a proposal for modification. At this stage, Commission may propose a modification before disallowing the combination, that this proposal we can approve. The proposal is sent to the parties. Parties may submit an amendment to the proposal of modification within 30 days, or parties may accept the modification. If parties accepted the modification, parties has to carry out the modification under section 31(4). If parties submit a modification to the proposal, Commission will reassess it. If Commission accept parties' proposal, it is accepted as approved with modification proposed by the parties. If Commission does not accept parties' proposal, Commission will resend the proposal to the parties to be accepted within 30 working days. In that case, parties has only one option, whether to accept it or not. If parties accepted the modification of the Commission, combination is approved. If it is not accepted by the Commission, it is deemed to have AEC. Section 39, subsection 1. It means that now there is no back and forth. The proposed combination will deem to have an AEC. With this, the approval of order part comes to close. To summarize, deemed approval, section 31(11). In case after all this process, the 210 days time limit crossed, then in that case, the combination deemed to be approved by the Commission. So cognizance of non-notifiable transaction, we have already discussed section 29, subsection 1. Within 1 year from the date of closing of transaction, Commission may make an inquiry into any combination which was to be notified to the Commission and has not been notified, to assess whether the transaction was having any competition impact or not. Appeal against the order of the Commission can be filed in NCLT and Supreme Court. Other relevant regulation. These are the recent changes has been made in the combination regulation for the purpose of facilitating the approval process, because it's a very lengthy process and time consuming. In order to help the parties to the combination, certain recent amendments was made. We have discussed the filing part, processing part, and approval part. Now, in these 2 slides, we will be discussing some recent changes which are helpful for the purpose of law. intimation of any change. It may happen that after filing of notice, certain material changes has happened in the transaction or to the parties. Therefore, the combination places an obligation on the parties to inform any change in information provided in the notice at earliest during the continuation of proceedings under the Act. The Secretary CCI shall place this information before the Commission not later than 3rd working days, within 3 days. Then Commission shall assess the significance of information and if satisfied, take on record the information. If the changes are material, Commission may invalidate the notice, may give and before invalidation, Commission may give an opportunity of being heard before invalidation. No additional fees shall be payable if notice is filed within 30 days. Once the notice is invalidated under this regulation, parties has to require to file a new notice without any fees if it is filed within 30 days. Regulation 16A at withdrawal and refiling. Sometimes may happen that parties are required to provide a substantial information and they may need some more time, which may not be prudent to stop the clock by way of defect rider or waiting till long. Therefore, this regulation was introduced which says that at any time prior to issuance of notice under section 29 subsection 1, which means issue of show cause notice of prima facie opinion to the parties. The Commission may, on request of parties has to request to the Commission to the combination allow withdrawal and refiling of notice. Parties may request the Commission to allow them to withdraw the notice, provide certain information and refile the notice. In case of withdrawal of notice, the fees already paid in respect of such notice shall be adjusted against the fees payable in respect of notice given by the party, which means the new notice when parties will file after withdrawal is not required to be paid any fees, and the fees already paid by them in previous notice is adjusted with the new notice, provided new notice is filed within 3 months from the date of withdrawal. Regulation 17, which says termination of proceedings. As we know that the start of this proceedings started with the filing of notice before the Commission. When the proceedings under this combination regulation terminates, the same terminates on receiving an intimation from the person or enterprise that the proposed combination will not take effect, or passing of an order by the Commission under section 31. It may be of any order, whether approving order, not approving order, or approving with modification. If the approval is conditional, means the approval was granted by the Commission subject to carry out of modification by the parties. In that case, the proceeding shall terminate upon acceptance of compliance report from the parties by the Commission. So with this regulation, the proceedings before the Commission under combination regulations comes to an end, and our session also ends with this.
Thank you, sir, for these enlightening words. Now the floor is open for question answer sessions. If there are no more questions, I would like to propose a vote of thanks for Anuj sir. Sir has given a very explicit graphical representation of this whole working of the regulation of combination under the competition law. Sir, we are very thankful to you for taking out a time from your very busy schedule and enlightening us with all these practical niceties of how the Competition Commission actually regulates the combination. The explanation was very simplistic in nature, because whenever we read section 5 and section 6, it becomes too much difficult to comprehend that when the combination is actually regulated by the Competition Commission and when it becomes free from the glitches of the Competition Commission. So thank you, sir, once again for taking out your time and enlightening our audience. We are looking forward to have your physical association with us in future. So it was a very informative session. So thank you once again. Now there are further announcements have joined the session. So I, Assistant Professor Mayura Sabne, Program Officer of this Marathwada Mitra Mandal Shankarrao Chavan Law College, International Conference on Kaleidoscopic Vision of Competition Law, A Way Forward, organized in collaboration with Department of Legal and Social Studies, University of Chieti-Pescara, Italy, under the aegis of the Competition Commission of India, welcome you all to this panel discussion, that is our third session for this day 1. Today, we are fortunate to have among with us two panelists who are well-known competition law practitioners at national level. So, before proceeding further with the panel discussion, I would like to introduce today's guest to you. Our first panelist is Advocate Devanshu Gupta. Advocate Devanshu Gupta is an associate in the corporate and commercial team at Link Legal Delhi. He has extensive experience in competition law and merger control practice. He holds a master's degree in law from Jamia Millia Islamia University, Delhi, and an undergraduation from Dr. Ram Manohar Rohia National Law University, Lucknow. Before joining Link Legal, Devanshu sir has worked in the office of founding chairman, Competition Commission of India, Competition Advisory Services LLP, and has acted in many cases concerning competition law enforcement, cartelization, dominance abuse, merger clearances, policy and regulatory strategies, and compliances. He is a panel advocate in Delhi Legal Service Authority South and has also contributed to various publications like MC Bhandari's Guide to Company Law, 20th edition LexisNexis, SM Dugar Guide to Competition Act, 7th edition LexisNexis, Manupatra Journal, Cuts, and Vivekananda International Foundation. Sir, I welcome you all on behalf of Marathwada Mitra Mandal as well as on behalf of University of Delhi. Now, our today's second speaker is Advocate Ketan Mukhija sir. So I would like to introduce Advocate Ketan Mukhija sir. Advocate Ketan Mukhija sir is a partner with Link Legal India Services, New Delhi. Prior to this, Advocate Ketan sir has led the general corporate team at P&A Law Offices. He was previously associated with Kanoria Foundation as the Group Senior Vice President for Legal Strategy and Corporate Planning. He was responsible for handling the in-house legal functions with the said leading group for over 300 companies in the infrastructure space, having numerous associate entities spanning a widespread business portfolios and sectoral verticals, including energy, road, oil and gas, to name a few. He was also associated with Herbert Smith LLP UK as a solicitor in 2008, wherein he was the part of the core team that advised Bradford and Bingley Place, UK's biggest buy-to-let lender, on raising funds and fresh capital. Ketan's primary area of focus comprise corporate restructuring, investment transaction, private equity, banking and finance, energy and infrastructure, real estate and construction, telecommunications, as also capital markets, both domestic at an international level. Advocate Ketan sir has completed his BLLB honors from Nalsar University of Law, Hyderabad, and he is also a qualified company secretary having considerable familiarity with the laws of several jurisdictions, including UK, continental Europe, Africa, Southeast Asia, together with their financial and accounting system. Advocate Ketan sir is an executive member of ASSOCHAM, National Council on Law and Policy, ASSOCHAM, National Council on Competition Law, and he has to his credit various memberships at national and international levels. Advocate Ketan sir has been endowed with various awards and accolades, including but not limited to Rising Star in Legal Fraternity by Legal Era, Chairman's Awards for Outstanding Performance by Kanoria Foundation, recognition as an industry leader by Chambers and Partners, and several others by IDEX and Lex Witness as illustrious legal conferences. Sir, we welcome you on behalf of Marathwada Mitra Mandal Shankarrao Chavan Law College and University of Italy. Now, I would like to request either of you to start with the panel discussion as per your convenience.
Sure. Thank you very much, Mayura ji, and good afternoon, good evening to all the panelists and all the audience delegates, etc., who are participating at this conference. Devanshu, if you want to go first, please feel free. Otherwise, I'll
No, sir.
defer.
No, sir. It would be great to listen to you, sir. Please, sir.
Mayura ji, how much time do I have with your permission?
Sir, 15 to 20 minutes.
Okay, fair enough. Thank you. So I'll probably like to start with firstly congratulating the Shankarrao College for hosting such a good conference and timely conference rather, along with the CCI and the University of Chieti-Pescara in Italy. And of course, celebrating the anniversary, 75th anniversary of the Indian independence as Amrit Mahotsav. It also gives me happiness and pleasure to be able to participate in this. And talk about the practical aspects of the competition law from the contemporary and issues and challenges perspective. Let me start off with a disclaimer and caveat first. So disclaimer is I'm not a competition law expert at the core. I am more of a corporate and commercial lawyer, a generalist. But of course, during the practice, during the past 15 years with several in-house firms, several jurisdictions and clients, of course, I've had my share of experiences with antitrust and monopolies and EU directives and of course, Indian competition law, which is why I would like to share some experiences, share some insights, what we have come across, and hopefully they will be of some help and importance to the delegates here. Let me start off by saying that, what I see of this legislation is a very oft-quoted aphorism, whether there is, of course, a problem which any law or any legislation or any regulation tries to address. Now, whether it's the problem of the market which operates within a society or a societal problem which operates within a larger spices of the market, what is it, which is what this particular legislation seeks to address to a large extent. In that sense, this is a dynamic legislation. It is also a legislation which is not devoid of market realities, social problems, and as is clearly highlighted in the preamble of this entire act, there is always something called a short title, a preamble, and a recital. Now, the preamble of the Competition Act 2002, I think, mentions 4 things. One is, of course, prevention or preemption of any activities which have any adverse effects on competition. What is adverse effect, etc., is of course, subjective matter, which has now been objectivized by the various judicial precedents, a lot of sections, a lot of provisions, a lot of jurisprudence which has flown in. But one, of course, the first is to prevent any practices which have any adverse effects on competition. The second is, of course, a more affirmatory or rather positive step, which is regarding promoting competition in the markets and in turn the society that we live in. Number 3, from the consumer's perspective, from the customer's perspective or the client's perspective, their interest to be protected as consumers. And number 4, of course, from the trader's perspective or the businessman perspective, to ensure that the freedom of trade, which is guaranteed by the Constitution of India under 19(1)(g) and other articles of the Constitution, is well protected and ensured by other market participants as well. Now, in line with this particular 4-pronged preamble, the CCI has been made the regulator. And without going much into the contextualization or conceptualization of what the act is, I'm safely presuming that we are addressing a very elite conference or rather audience here. So I don't want to bore you rather, with what the CCI is, what the mandate of the competition is, but rather focus on some of the experiences that I've had in my practice of corporate and commercial laws, which includes banking and finance, which includes in-house perspective from the client's perspective, which also includes some cross-border transactions, etc., what we have come through and how we perceive the Competition Act to be a progressive or otherwise step in that direction. Now, of course, let me start off by saying that, competition law, given these 4-pronged preamble, firstly tries to prohibit the anti-competitive agreements. Now, anti-competitive agreements can take a form of a cartel, can take a form of an arrangement to limit the production and supply of a good, agreement to allocate the markets, to fix the price, which are all contained in articles, or rather sections 3 of the Competition Act. So these are the various sections which talk about 3, 4, 5 are the operative sections, as we call it, the substantively operative sections of the Act, which talk about the prohibition of anti-competitive agreements. The next set of articles or sections talk about the prohibition of abuse of dominance. And then there is section 5 and 6, which talk about the regulation of combinations. So what I propose to do is I propose to touch upon specific challenges that we have come across on the practical side. So may not be strictly legal, but rather from a market/practical perspective, what we have seen and how the CCI has reacted to them. So when we talk about prohibition of anti-competitive agreements, there can be horizontal agreements, there can be vertical agreements, there can be several different kind of creative and innovative agreements which the clients, the various market participants come up with. So in that sense, obviously the abuse of dominant position can happen by imposition of any unfair or discriminatory conditions of pricing or the purchase conditions itself. It can also take the form of limitation of restricting the production of goods or services or the R&D, the research and development, which is associated with that product. It can also take form, manifestation of denial of market access to new or existing participants. Now, what are the problems? The problem is, of course, if you're talking about, say, I come from an infrastructure background. So infrastructure background typically involves long-term contracts like concession agreements, long-term supply agreements, long-term purchase agreements, etc., which are essentially having some kind of implication and impact on the competition law. So when we talk about a long-term contract of, say, purchase and supply with a instrumentality of the state, say, department NHAI contract or a port contract, etc., they tend to be a long-term concession agreement. And by virtue of that, they are having some kind of inherent monopolistic tendencies and barriers to trade. How do we deal with that? What we have seen in the recent past by the jurisprudence of CCI is there is a lot of focus on 4 or 5 things in line with the constitutional mandate, in line with its own preamble, and in line with its own underlying objective. One is, of course, the compliance. Compliance regulatory structures have been strengthened to ensure that the business environment is competitive and non-compliance is penalized. So recently, if you see the judgments of or the orders under 26.1, 26.2 of the CCI, you will notice a significant change that what kind of focus is being placed by the CCI is on market correction, is not on levying the penalties because you have breached a particular provision, breached a particular stipulation, or having an anti-competitive agreement in place. It's not simply to just do a black letter kind of an exercise by imposing a penalty by virtue of a standard formula and penalizing the culprits. It is more on market correction. It is using its advocacy wing to spread the entire knowledge and awareness of the competition law provisions in the ever-evolving market. I said some time back, it's an economic legislation. So when we say economic legislation, law and economics cannot be seen to be mutually exclusive. So they have to be read in tandem. So what we have seen is CCI has been proactively, at least to my knowledge, it has relatively and proactively dealt with a lot of organizations like the Chambers of Commerce, the Chambers of Industry, etc., to promote the knowledge of competition laws and underlying regulations. Why it does that is to ensure that not just in the instance of a combination. So assuming a mega merger is taking place, then you go for filing an information, seeking an approval, etc., of the CCI. That's fine. But on an ongoing basis also, whether you have a distribution ship agreement, whether you have a sale and purchase agreement, any kind of agreement which may or may not have a non-competitive or anti-competitive effect is being now talked about. We have a lot of clients. So from a practitioner's perspective, we are having a lot of clients, both India and overseas, to tell us that, what kind of compliance structures are required to actively identify what risks can be abstracted and then mitigated. So if they have a long-term agreement in place, which has a non-compete clause, how to make it in conformity with the legislation so that tomorrow, if and when it does come into scrutiny, they are not really levied with a lot of penalty. So that kind of preemptive or mitigative approach is really welcome. The other thing that we are seeing in, of course, the recent jurisprudence is the investment focus. A competition compliant business indicates a good corporate governance program to all the stakeholders, including the regulators. And that enhances the ease of doing business by the investors. So if you have that focus that, this is aligned and streamlined with the aim of getting the investments into India, whether it's startups, MSMEs, smaller industries, or even mature businesses by way of strategic investments, that also the commission has taken some kind of step to ensure that there is an objective criteria that we have to meet these, and of course a contextual criteria, the rule of reason. I would not go into the jurisprudence because everybody's aware of that, how an agreement is treated, an anti-competitive agreement, what are the benchmarks, criteria, and yardsticks to treat one agreement one way or another. But the focus of the commission is on preemption, that you do not have these agreements in place, which may lead to an abuse of dominant position by a certain player. Recently, we have seen a lot of scrutiny against the e-commerce players, like Google, like WhatsApp, like so many other players, Flipkart. They are trying to have all the internal set of agreements, policies, etc., in compliance with the regulatory framework, again, which goes into the root of the preamble. It prohibits any anti-competitive agreement because, of course, the players are a profit-making entity. So there is you cannot attribute blame to them because they're doing the business, but at the same time, a responsible business, a compliant business. That brings me to my third point. How are they ensuring that? Because having a law, so India is known to have hundreds of laws in place, the maximum number of laws, in fact. But having a black letter law in place, but not having the implementation and having a symbolic existence of law is very different from having an implementation, a successful implementation and execution. That is where I think the CCI is increasing its scrutiny as well. So the Competition Commission has been proactive in dealing with information concerning this behavior. So that is another challenge, what we come across, that, there can be a scrutiny of what kind of agreements you have, what kind of business partnerships you have, what kind of communications you have, what kind of internal policies you have. So which is where we advise the clients to ensure that all their regulatory, legal, and contractual relationships are robust and compliant. Of course, as a matter of the business, they will be participating, or they will be members of trade and industry organizations also. They will be operating as a player within, say, if you are a pharma player, then you will be a member of the pharmaceutical association. Similarly, any other manufacturing sector will have its own trade association or manufacturing industry association. How do you interact with them? Whether any price rigging is taking place? Are the tendering processes competitive enough? Are they following the CVC guidelines? All this is now being regulated, monitored, and overseen by the CCI. And it does not only act on behalf of a complainant or an informant, even on behalf of itself. Suo motu cognizance it's been taking. In a lot of cases, in the Maruti Suzuki case, we have seen if there are certain structures which are operating in the market for, say, discounts, rebates, unfair pricing, that is now being taken cognizance of by the regulator in a very proactive manner. So that needs to be, and therefore the message to the players is that, they have to be vigilant of what they sign, how they sign, and what kind of contractual arrangements they have. Similarly, the emphasis, what I have seen, is on mitigation as well. One, of course, is, remedial. When the damage is done, you go to the CCI, you go to the Compact or NCLAT now, or you go to the courts for remedies. But the other is, of course, mitigation. So mitigation is, of course, there is a lot of leniency program, green channel program, which is being run by the CCI, which emphasizes a lot of thrust on having a mitigation program. So if you think that, as a client or an consumer or a market participant, that, there's something which you may have not done exactly by the letter of the law, or by the purpose, or by the, the objective of the law, then you can, of course, inform the CCI with full disclosures, and there is a leniency program which is also being run. So the four-pronged message that I would want to give on the first leg is you have a good, robust internal monitoring and reporting kind of a mechanism. So if you are a market participant, then I think the structures internally are robust enough to ensure the monitoring, the audit, the reporting mechanisms are solid. Number two is, of course, the regular training of staff. So if you have key managerial personnel, including the directors, because of fiduciary responsibility that they have under the Companies Act and various things, they should all be aware. So there can be regular training, there can be compliance manuals, there can be workshops, etc. But some kind of periodic training of the top management and the operative management is very necessary if you are representing a market participant, which basically can be a trader, manufacturer, service provider, or any organization of sorts. Number three is, of course, having some kind of good paper trail and measures in place by way of internal policies, whereby you have a maker and checker mechanism and adequate checks and balances to firstly preempt, and secondly, if at all they arise, to kind of remedy any anti-competitive behavior. So what we often, because of these challenges, we often offer a compliance program to various clients, and that has been taken very encouragingly by several players in the market, which talks about developing a competition strategy, ensuring a prompt action, improvement of the internal policies, having an exhaustive manual, etc. And as a lawyer, although we insist on remedial, but I think as more of a person who is equal stakeholder in this economy, I would rather say that it's always beneficial for the market players to develop a mitigative and preemptive approach to co-opt any kind of measures, whether it's penalty or any kind of a measure which is taken by the CCI, by ensuring that yes, there is an active risk identification, mitigation, and management thereof in anticipation. That always helps. So that was my first point, which I come across as challenges in terms of their internal policies of contracts and how possibly they can remedy that. Number two, of course, is the focus of the CCI on the market realities, as I mentioned earlier. We have seen the recent Amazon case, we have seen the Maruti Suzuki case, we have seen the future retail matters, etc. The focal points of CCI interventions have now been to bring about the swift market correction so that the businesses can compete on merits, irrespective of their size. It can be a small, big, medium player, etc. And more importantly, ensure that the consumers also benefit from improved market outcomes. Now, how they do it is not by simply imposing a heavy penalty. They also make a reasoned judgment. So in all the orders, you will notice that they will identify specifically what kind of breaches happen, so it's obviously what the relevant market is, how the relevant market has been abused, how the relevant market has been abused in that particular context, etc. And that is corroborated by the factual evidence and of course the legal provisions. And once that happens, either the appeal may lie before the NCLAT, etc. But the kind of jurisprudence which is emanating, of course, it's for the CCI to see that lesser and lesser appeals are, overturned. But of course, the idea is to understand by more reasoned orders that, such and such breach is happening, a market contravention, the nature of contravention, and kind of preemptive step which can be taken for the proposed contravention can take place. So in most of the orders, you'll see a 50, 60 page order, which also tells you about the kind of breach which has taken place, the kind of behavior that was expected under the law, but the kind of breach which has happened on the factual positions in front by the particular competition player. That was the second point that I wanted to make, that, the kind of adaptation that the CCI has seen as the regulator, not by just imposing the law black and white, but to see the contextualization of the entire market dynamic and then imposing, transposing, and using that in its own jurisprudence by way of orders and regulations. Number three, and this is my final point. Of course, I'm happy to take any questions, etc. But just giving an overview of the questions, or rather the challenges from my experience, that competition law is still a very young legislation. It's not mature. Even though it's from 2002, it was put into effect in 2009 after the constitutional validity was ascertained and affirmed after the Brahmadatta judgment. Still, over a decade it has been, but it's far to go as compared to the US antitrust laws or the EU directives or the commission laws, etc., which are more mature jurisdictions. And to that extent, I think, I must laud the legislature that they borrow the best of all worlds. So although we are heavily dependent on other jurisdictions, sophisticated jurisdictions for making the laws, but the idea is to get the best of all worlds, but not blindly follow it. So in that sense, competition law has been relatively young. It's still in formative stages. And what I've recently seen is the kind of subjectivization under the law has been subject matter of jurisprudence, and therefore it is sought to be objectivized. By that, I mean that, if assuming, under the law, it says that if you have a particular agreement, which is limiting or restricting production of goods, supply, technical or scientific development, etc., then this can be interpreted in manifold ways. However, we are now seeing that, as it's growing from its nascent stages, it's trying to mature. The CCI orders are also trying to give some kind of objective standards to all these kind of parameters to ensure that, it's interpreted in a more uniform, standardized and consistent manner. So to that extent, the kind of discrimination or some kind of ambiguity is going away, because the more objective the law is, the better it's understood by the market participants, the better it's executed, and the better it's regulated. Similarly, on denial of market access, what is dominant position in one relevant market, how do you protect the other relevant markets, etc. It's now being objectivized by the jurisprudence. So this is one law which is actually taking a lot of cue from the context, from the evolving business dynamic, and from the behavior of the market players, and then trying to adapt from it. But of course, there's a long way to go. We cannot really instantly compare it with the EU Commission or the US antitrust and monopoly regulator, but I think it's going in the positive direction, and we all have a role to play in contributing a bit towards the improvement and towards the successful implementation and execution of the law. Thank you.
Thank you, sir, for such a delightful explanation of the competition law. Now I would like to have the views of Devanshu, sir, about your views, what you have talked about the practical implementation and the challenges which you face while you are implementing the competition law. Over to you, sir, Devanshu, sir.
Thank you, ma'am, and a very good afternoon to all. I must convey my compliments to the principal, sir, professor and a student at Shankarrao Chavan Law College, Pune, for organizing today's event at an international level and in collaboration with the Competition Commission of India. It is indeed my pleasure to interact with you today and discuss the practical aspects of competition law, the contemporary challenges and issues. As Ketan sir has already very vividly discussed the practical aspects of enforcement of competition law in India, I would like to touch upon the pace at which the competition law jurisprudence is being developed in India. So basically last year on 20th May, Competition Commission completed its 12 years of enforcement. And in its short time, it has won a place on a table of market regulators worldwide. Though it's young, it has adjudicated over 1,100 antitrust cases in diverse sectors of the economy. And it has come to a conclusion after making an in-depth analysis and keeping in mind the market structure, the nature of contravention, and these factors while making its decision. And during the pandemic, the CCI was also noted for its unique approach of restraining from imposing big penalties on MSMEs and loss-making entities. And simultaneously, on the other hand, the CCI did not shy away from moving against companies like Amazon, big companies like Amazon, Facebook, WhatsApp, Google, etc. CCI has been delivering a lots of orders, and in March, it is noteworthy that in March 2021, the CCI passed an order directing DG investigation in the WhatsApp case for abuse of dominance. The CCI also found Carlsberg and other beer manufacturers guilty for cartelization and imposed a penalty of rupees 870 crore, around 870 crore. However, like many others, order being challenged, this particular Carlsberg order, the beer cartel order, was also challenged in NCLAT, and it is pending in appeal. So it may be noted that the CCI orders are mostly CCI orders are pending in appeals before NCLAT, and this in a way is delaying the establishment of concrete competition jurisprudence in India. So as a solution to this, the Competition Law Review Committee, which was set up as an expert committee to review the competition law framework in India, it recommended the provisions for settlement and commitment mechanism that must be added in the legislation to counter antitrust cases and to cater the problem of pending appeals in NCLAT. So these are the Competition Amendment Bill 2020 is pending in Parliament, and it will be very interesting to see the effects of such provision, adding such provisions in the legislation. Well, these provisions are being taken from foreign jurisdiction, basically US and EU. So it is expected that they are going to give a long way in settling cartel cases, and that delay which is being caused, and for that reason the CCI jurisprudence is not being totally established. So this will in a way settle that. And CCI, it is also for CCI, it is also very important to bring uniformity in its decision, and that can be developed through development of a concrete competition law jurisprudence in India. So that again will take some time. And in my understanding, CCI should also now focus on competition policy and devise a mechanism to follow up on effects of CCI orders in the market, that to what extent the orders of the CCI are being implemented in the market. And this can be also done as part of extended market and sectoral studies undertaken by the CCI as part of its advocacy mandate. Uh, so in short, these are the current issues, I think, which needs to be seen. And before I conclude, I would again like to thank for this opportunity and mention that the competition jurisprudence in India is still evolving, and the CCI would have a key responsibility to discharge in helping Indian markets evolve. Further, with the emergence of digital markets and e-commerce, the role of CCI is at the central stage now for effective oversight and necessary interventions. As competition law directly affects consumer growth, consumer welfare and economic growth, it holds great relevance for future India. And therefore, I would encourage students at Shankarrao Chavan Law College to get the training and exposure in competition law. And as CCI has started giving virtual internship for students, so it will be a great opportunity for students to join. And further, the CCI has also opened new office in Chennai, and mostly in Mumbai it would be coming soon. So it also says that the competition jurisprudence in India is going to develop, and it is going to flourish in the coming times. So with these words, I would like to thank you for the opportunity for giving me to speak on this event.
Thank you, sir. I would like to bring to all of the notice that every month one of the student gets selected for this CCI internship in online mode. So till now, 5 of our students have done the CCI internship till date. It's a very proud matter for us, and now CCI is collaborating with us for these advocacy functions. As far as your point of contention is concerned, that it is very well true that competition law jurisprudence is developing. And as Ketan sir has already pointed out, that though CCI is taking efforts to develop this competition law jurisprudence, there is a long way to go. That means CCI need to learn, need to adapt. But what our observation from the academics perspective is that the competition law itself is not well known among the academics. That means there exists certain kind of law that advocacy is missing somewhere on the part of CCI. That's why we have organized this initiative, that what is this law and how that law can be beneficial to the upcoming lawyers, how that law can be beneficial to the consumers. They need to understand it, that how competition in the market affects us. And whatever points both of you have discussed, they are very well true. And while studying from academics perspective also, these challenges we can see when we study the case laws at different points of time. And as Ketan sir has pointed out, that whatever recommendations you give to your clients that are very much needed, that is the need of the hour, so that the competition will be maintained properly and the role of CCI will be minimum one, so that the market players will themselves regulate in a very proper balanced way. So now I would like to have the opinion of Ketan sir about the perspective which has been given by Devanshu sir.
In addition to what Devanshu said and I mentioned earlier, Mayuraji, I also probably I mentioned more for on a higher level from a vantage point, 50,000
Yes.
feet level. So I wanted to just supplement what I said, maybe, with some kind of processual or nuanced points for the students also, which in my opinion can come very handy for them for becoming a successful and a competent competition lawyer. So I think, and all these granularities, with due respect to all the law schools, may not be touched upon because the sheer course breadth and width and the depth. But these are very important when they work in an internship, etc. How to draft an information, appeals, replies to the Directorate General and the opposite counsel, minor documents like, application for recall or review of the orders, inspection letters, extension letters, how to draft a legal opinion with respect to exclusive vertical agreements by various companies depending on their respective sector. It can be a tech company, it can be a publishing company, FMCG, etc., etc. Preparing various advisories, resale price maintenance, investigation orders which are passed by the CCI, how to defend. So if somebody wants to go into litigation, how to defend a case of bid rigging, MRP, predatory pricing, exclusivity, output restrictions, how to draft these applications for target based exemptions. If somebody is in transactional practice doing mergers and acquisitions, how to draft an application for target based exemptions, parties test, etc. How to assess the appreciable adverse impact on competition for merger transactions. So all these things are very granular, but they're very important. What is Form 1? How to vet a license agreement? How to process a composite transaction control? How to identify relevant markets? Gun jumping? I can go on and on. There can be like at least 50 pointers for the students to look at. But the broad messages, Mayuraji, which I wanted to convey to
Yes.
all the students and aspirants and existing practitioners, which involves us as well, to try and learn as much as we can, because as we mentioned, this is a nascent form of legislation. There's a lot to be learned, there's a lot to be borrowed, there's a lot to be contextualized. So wherever we see synergies, if they are doing internships with a tier 1 firm, tier 2 firm, whichever firm, the best is to try and absorb, digest and abstract as much as they can in terms of what is the substratum, what's the point which they need to be wary of while giving credible. Because once the client comes on board, once you reach that position that you have a lot of clients, and I'm sure you all will, that they will look to you for credible advice. So until and unless your fundamental concepts are clear, that will never come out. So idea as to how drafting is required, both on substratum, which is substantive aspects, and on the processual, which is the procedural aspects. On both fronts, I think the idea is to develop as much competence as possible and take as much experience as possible. So whether it's competition diligence, whether it's an assessment of gun jumping or interim relief application, a competition risk analysis, because in most of the things, whether you are practicing like a practitioner, doing a general law practice, even litigation practice, competition law is all pervasive now. There's no avoiding and missing the competition law. So I think it has a spillover effect on all of us. So that is just a suggestion from my end.
Yes, sir. Thank you. Thanks a lot for enlightening our audience. Devanshu, sir, if you wish to say something.
Conferences like these are very important for everyone, and since after the pandemic they have gone online, so the dissemination of knowledge is taking uh, a, a big step now. So a big thank you to you, ma'am, and the organizing team at Shankarrao Chavan Law College.
Thank you, sir. Now I would like to propose a vote of thanks. Before that, if there are any questions, we can have it. The floor is open for the questions.
Madam, can I ask a question here, ma'am?
Yes, yes.
This is Samrat here, madam, and I'm very thankful and must appreciate the way how Advocate Ketan Makhija sir and as well as Advocate Devanshu Gupta sir has posited the different points. But having said that, actually, pardon me, sir, I actually want to actually ask two questions to Ketan sir and two to Devanshu sir. Is that Ketan sir, Advocate Ketan Makhija sir, I just want to ask you, because you did pertinently talk about the different aspects related to gun jumping and, the different aspects related to how the CCI's investigation role is actually increasing as we seeing the light of the day. So what I'm trying to understand is that what is your opinion on the very fact that, for example, there have been number of initiatives which have been taken, for example, having the due process procedure in place, for example, related to the, say, dawn raiding procedure or gun jumping procedure. So do you think that these are actually, for example, if a gun jumping procedure is being initiated post the dawn raiding happening, so do you feel that during the dawn raid also, like, so for example, there are a number of natural justice parameters. For example, the two witnesses has to be taken, and in fact, you have to have even the lawyers present of the company. Do you think that if those kind of parameters are not there, can you sacrosanctly tell that those kind of things are not a part of the normal procedure? That is my first question to you. And the second important question I want to ask you is that, so when it comes to refusal to deal, which is a part of the vertical agreement. So in that particular refusal to deal, is it only restraining, typically, even if it is not a combination, it is a relationship which is established in a vertical market with the vertical stakeholders, if any restriction is being posed per se. So how do you see that those restrictions actually playing out in reality? Do you think that those restrictions, because nothing is defined as a restriction in the refusal to deal, sir. So what is your take on that one through jurisprudence, through your normal practice?
So should I take question number one, or?
Yeah, Devanshu, please go ahead.
Yes,
I will. Okay, so Devanshu, why don't you answer? Then I will just supplement that, because it's a good question.
Yes.
Yeah, both of them.
Yes. Actually, basically, the Competition Act in India is guided by the principle of natural justice, and as a matter of fact, every commission and tribunal is guided by the principle of natural justice. So the orders given by the commission are right in rem, and even if you see the investigation in the DG office that are governed under the provisions of Companies Act. So a Supreme Court has also dealt with the issue in the JBL matter, and it has said that the DG has appropriate power to seize and to collect evidences during the dawn raid. So these are the power with the CCI, and CCI has been for these reasons actually. If we trace back the origin of the Competition Act and departure from MRTP Act was just because there was no effect doctrine present in the MRTP Act. So Competition Act under Section 36 and under Section 42 and 43, it has been given the power to give effects to its order. So that way, the CCI, there is a separate rules and regulation governing the competition jurisprudence in India. So these are the major things for for a practitioner to know. If there is anything that you want to.
So gun jumping is not. So I think it's correct. So Samrat, I think gun jumping is one very tricky part for all the practitioners. Also, I am talking like a practitioner now. So gun jumping is not defined. The procedural gun jumping or the substantive gun.
Section 43 says about the penalty aspect 1%. Even Anuj sir actually took it the prior session, sir. But
very interestingly,
what Devanshu Gupta sir has mentioned, what was about the natural justice principles. So which indirectly means that during the dawn raid also there needs to be some kind of flexibility which CCI should actually display, I guess, when it comes to actually ensuring that the players, even the lawyers, representation.
See, which is why you're seeing a lot of appeals to now NCLAT. If you see, most of the SEBI judgments are going to SAT. Similarly, CCI judgments are going to NCLAT are being overturned as well. So principle of natural justice, even if not expressly enshrined in the competition law, is a fundamental constitutional tenet. So it has to be, the other side has to be represented. For any jurisdiction to be a mature jurisdiction, like, you cannot have a criminal not be substituted or, assisted by a lawyer is not allowed at all in the foreign jurisdictions. So which is why even at the expense of having, giving lawyer or representation, this is one major ground for setting aside any CCI order if he's not well represented. So even if the appeal provision 43 talks about 1% to be levied, of the total turnover, etc., that is true. But at the same time, these provisions, even if not expressly laid down, form a part of the constitutional tenet and therefore form part of all the procedures, powers, processes of the CCI. Whether they take the gun jumping measure, dawn raid guidelines, or investigations, this particular principle of res ipsa loquitur and natural justice, odi alterum partem, has to be followed.
So how about my second question, sir, which is refusal to deal? There are a number of cases, for example, there are some agreements, licensing agreements, which happen between companies, typically happening even in horizontal agreements. For example, independent director becoming a member of a board member in another company, competing company, which is fairly fine. And also the shareholding patterns, for example, the control of ownership and the shareholding patterns, that if it is less than 10% also. So that case, it shouldn't attract the provisions of the competition law per se, isn't it, sir? Because
Devanshu, do you want to answer that? No, understood. Earlier also, we got the gist of your question. Thanks, Samrat. Devanshu, would you like to react to that?
Yes, sir. Yes, sir. Actually, there are certain exemptions that CCI follows, and they are given in Schedule 2 of the combination regulations. These exemptions, if any enterprising going on with a merger or with anything, so if they are falling under these exemptions, so they are not supposed to file a notice with the CCI. So it is important to have a detailed knowledge of these exemptions for enterprises to not go to the CCI unnecessarily.
So I think, what we can also do is, Samrat, my suggestion is, if you read the judgment in Kansas News versus Fastway and others, I think, CCI has actually dealt with the jurisprudence
Can you please repeat the judgment, sir? Please repeat the judgment.
Canson News versus Fastway and others.
Yes, please. Thank you.
So that will be a judgment which tells you about the contours of denial of market access, how the ramifications of this can be treated, and the CCI has also dealt with. So this was actually upheld. This went to compat. Then it went to the Supreme Court. So I think you'll have a fair idea of what the maker and checker mechanism in respect of denial of market access is. I think it's a very effective judgment. It talks about the mandate of the act also. It talks about the competitors also, that, to maintain the effective competitive process, but not the competitors, just the process, and the court's interpretation to mean that, any form of denial of market access how it amounts to abuse of dominant position, etc. or not. I think this is a worthwhile read on the specific question that you asked.
Yes, sir. It's a very good insight and a very comprehensive answer to Mr. Samrat, sir. So now I would like to conclude this panel discussion by saying that both Ketan sir and Devanshu sir has given us a very good practical insights into the dynamics of the implementation of the competition law. Since the beginning, we are talking about the theoretical perspective. Now we are well aware about the practical perspective as well. So thank you once again, Advocate Ketan Mukhija sir and Advocate Devanshu sir, for accepting our invitation and joining this session and enlightening our audience with respect to the practical aspects of the competition law. We look forward to have your association with us in future as well, and to meet you in physical. We extend the invite to our college. Thank you, sir, once again.
Thank you. Thank you, everyone.
Thank you, ma'am. Thank you.
The feedback form link for this session has been posted into the chat box. Please fill it, and we will start with the next session within 2 minutes. Good evening, one and all. I, Assistant Professor Mayura Sabane, Program Officer of this international conference on Kaleidoscopic Vision of Competition Law, A Way Forward, organized by Marathwada Mitra Mandal Shankarrao Chavan Law College, Pune, in collaboration with Department of Legal and Social Studies, University of Chieti-Pescara, under the aegis of Competition Commission of India, welcome you all to this last session of day 1 of the conference. Today, in order to deliver this individual discourse, we are having with us Advocate Manmohan Sharma sir. Sir has completed his Bachelor of Sciences from the University of Delhi in the year 1977 and Bachelor of Laws from the University of Delhi in 1980. He has completed his postgraduate diploma in economics for competition law from the King's College, London. Sir is an advocate in the Delhi High Court and heads the competition law and policy practice in the law firm Vaish Associates Advocates since 2009. He has over 35 years of experience, including regulatory and judicial experience as a judge advocate in the Indian Navy of over 10 years. He holds a postgraduate diploma in economics of competition law from the King's College, London, and he has worked in the Competition Commission of India as additional registrar during 2006 to 2008 and was responsible for drafting the implementing regulations under the Competition Act of 2002. Sir has also worked as a head legal or in-house counsel in Jindal Steel and Power Limited before joining Vaish Associates. Advocate Sharma sir has advised and represented clients as independent counsel and antitrust issues before the CCI, the National Company Law Appellate Tribunal, High Courts, etc. in some of the noted cases, including some leader antitrust cases on cartels and abuse of dominant position. He has also some notable merger and acquisition filings in CCI to his credit. He is a prolific writer on competition issues and has few international publications in noted journals to his credit. Sir also runs an independent blog, the Antitrust and Competition Law blog. He also contributes updates on competition and antitrust exclusively from India in leading international law journals like the International Law Office, competitionfeed.com, Concurrences, Lexology, Mondac from India regularly. He is also editor of the firm's bi-monthly newsletter, the Competition News Bulletin, now in the 11th year of its publication. Sir has been a member of the Regulatory Affairs Committee of CCI and of MSME and many other committees in the PhD Chamber of Commerce. Sir, we are very fortunate to have you here. Sir is here to give us a practical insight into the emerging competition issues in e-commerce in India. So without wasting further time, I would like to hand over to Sir to enlighten our audience. Over to you, sir.
Thank you, Professor Mayura. I hope I'm audible.
Yes, sir.
Okay. Thank you. For some reason, I'm not able to share my video as of now, but I think I'll be equally capable of explaining to you what I wanted to say. So, friends, we are going to discuss the issue of emerging competition issues in e-commerce. I'm sure all of you are aware of the importance of e-commerce. So selling online or e-commerce appears to be the road to future prosperity, as we all know. For sellers, it reduces marketing costs, provides safe environment for transaction online, and reduces transaction delays, thereby facilitating faster sales and widens consumer base. For consumers, it offers wider choice of better quality products, services at cheaper rates, and brings transparency and provides comfort of home shopping. No doubt, buying online is fast becoming the preferred mode of buyers across the globe, especially the younger generation, due to the facade of abundance which is created on the internet, and the choices being just a click away. So e-commerce seems to have introduced real competition in market due to the above said, and has made consumer the king. So I hope we all are aware of the benefits of the e-commerce. No wonder most businesses want to include online selling in their market strategies. Our traders selling online face some common practical problems when they deal with any of these known e-platforms, such as one-sided contracts, delayed settlements, heavy commissions, lack of transparency, refund policies, fake product liability, etc. Now, in this talk, I'm going to explain to you the origin and main reasons behind these common problems of the sellers, and if they can be resolved under the competition law, how it can be resolved. Now, let me give you a little overview of the benefits of the potential of the e-commerce. So whether the potential of e-commerce in India is fully tapped. Please have a look at this slide. India's internet economy, which is expected to double from so-and-so to April $225 billion as of April 2017 to $250 billion by 2020. This is an old slide, so you can obviously update the data, but this is the kind of business we were expecting, we are having it. E-commerce revenues have jumped from $39 billion to $120 billion in 2020, and the growth rate is 51%, the highest in the world. Out of estimated $600 billion retail market, the share of revenue of e-commerce is only around 6 to 7%. So the e-commerce potential, you can see, is still to be tapped. Despite having a huge number of internet users, 665 million users as in 2019, the total online shopping was around 50 million. And of this 50 million, monthly purchases only were about 20 million e-shoppers. Most of these e-purchases are from the big cities. So there is an underutilization of potential of online sales. It is mainly due to market inefficiencies, including underdevelopment of a largely unorganized logistics sector. Now, which are the major e-commerce players in India? So in FMCG sector, we got Amazon, Flipkart, Snapdeal, IndiaMart, Myntra, BookMyShow, Paytm, etc. And the OTAs, that is online travel agents for hotels and ticket booking, you got MakeMyTrip, GoIbigo, Yatra, ClearTrip. You can see these names are very famous. You must not forget IRCTC also, is one of the first public OTA, so to say, started e-ticketing in India long back in 90s. And food delivery aggregators like Zomato, Swiggy are all very familiar with. Out of them, of course, Food Panda is gone, Uber Eats is gone. Some of them still remain. So taxi aggregators, Uber, Ola, Muru Travels, etc., etc. So this is the kind of major e-commerce players in India. And let us see the larger picture. I mean, how big these giants are. You see how big the e-commerce players are all over the world. So you can have a look at the size of the revenues of these big companies, and you must have read, may have read recently in the newspaper that Apple's market cap is more than the market cap of the GDP of India. It's $3 trillion. It has become now. So Apple, Amazon, Alphabet, Facebook, Alibaba, Tencent, etc. Now, what are the special features you see of the e-commerce? What are the unique features of e-commerce, if I may take you through that? So I just mentioned you about the practical problem which the sellers face. That is just in the practical point of view. But let's see the legal side of it. So let me come to the special features now, which makes the dynamics of competition in digital markets different than those in the normal physical markets. Please keep in mind that the online sales are preferred mostly by online retailers with less brand equity compared to traditional stores, chiefly because it takes time to build reputation and goodwill, and e-tailers are relatively new businesses. So who will come to the e-platform? Mostly the new emerging businesses. Most important, the prominence of the intermediaries is there. So the intermediaries become very prominent. And most of them are multi-sided platforms. So I think some of you who have some understanding of competition law, there are two sides of a market, the buyers and sellers, and the platforms, they represent both sides. So they have what is called as a network effect. There's a direct network effect and there's an indirect network effect. Direct network effect is seen in the case of social media platforms like Facebook, etc. And indirect network effect is seen in case of other platforms like the FMCG platform like Amazon, etc. So there is the role of the intermediaries, which are multi-site platforms. We have strong indirect network effects, the implications of the internet and other information technology tools, including the use of big data and algorithms. And these intermediaries, they create a unique platform governance ecosystem of their own. So what happens is there is competition on both sides. There is competition among the buyers on one side to buy the best of the product, and the competition on the seller side also, because sellers also compete on the platform to get a surge in the ranking, which in the normal circumstances should have been from the quality side, quality and price. See, mind you, competition has three core parameters. It's the price, the quality, and the speed of delivery. So these three core parameters the sellers compete on. But what has happened is, because of the unique platform governance system, they have created their own ecosystems. So each of these platforms have got their own ecosystems. And they have created a sort of private competition within the platforms, which is characterized by, unfortunately, by information asymmetry and opacity. So a seller doesn't know what the platform has signed an agreement with the other seller. They signed NDAs, non-disclosure agreements. So opacity remains supreme. And then the use of algorithms. So they will take your data. Once you join to a platform, you are supposed to give your basic details. And then they try to, you must have seen the movie called The Social Dilemma. So for each individual, each consumer, there are three, algorithms working. So they will judge your, the choices, your likings or dislikings. So if you start say, the moment you tap on something particular, you will keep on getting the same kind of, feeds from the particular platform. I think you must be very familiar with this. So this is a very unique ecosystem which is created, which has been created by the ecosystem, these platforms. So there is this is actually leading to market inefficiency in a way, and there's something called as adverse selection, and using the same sometimes to destroy platform neutrality or self-preferencing. Now, I describe this as a case of, if you can compare these, you can compare a platform like a digital, like a mall, a shopping complex. There is a shopping complex, there is a mall, then there is a superstore. So a shopping mall is actually a platform. You can compare a shopping mall with a platform with whereas a departmental seller, you see, if there is a departmental seller in a shopping mall, it's a reseller. It's directly selling its products, right? But a shopping mall is supposed to be neutral. A shopping mall should have nothing to do with what the goods are sold by the sellers to the buyers. So you must remember the difference between a shopping mall and a departmental store. So the digitalized, multi-sided platforms can be described simply as digital platforms, and the digital intermediaries that follow a reseller model are known as digital resellers. What is happening is, slowly, these digital platforms or the so-called department stores are turning into digital resellers. How? You must understand that. It is because that they also have stakes in the sellers who sell at their platforms. So the private labels, they have private labels. So once you have at stake, then you are not genuinely, then your competition cannot be equal, because you have the benefit of the data, which is with the intermediaries, that is the platforms. You have the benefit of the preference which the intermediary would give to you because you are a preferred seller. So obviously you will come in the ranking, you will come higher in the ranking. Of course, your price is your own choice. But at the same time, the other sellers, they get lost out in the competition. So what happens is, winner takes all. So the unique feature of this competition, e-commerce or the digital competition, is it is competition actually for the market, and it is not in the market. They somehow try to acquire competitors, and there's another interesting feature of these players is that they pursue growth at expense of profits. So they actually expand on all sides. So Amazon is not only a multi-sided platform. Amazon is also into making movies. Amazon is also into Kindle. So many things they have entered into. So all kind of verticals, horizontal expansion these players have started in. So at the same time, they will not show the profits on their books. What happens is that the income tax will say, well, they are not making profits because they have huge deep pockets. Imagine the case of Uber. I'll tell you some of those cases as I proceed. And these all cases have also been tried in India only. This is going on. And there's vertical integration all across the multiple businesses, the related entities. So dynamics of the competition is actually completely different. The basis, but interestingly, it is based on what is called as consumer welfare. So all of us would know that consumer welfare is at the bedrock of competition law. And these players are not very well. These large international players are very smart. They're all based in Silicon Valley in the US. They understand antitrust very well. And they know that the current, current theory of harm in antitrust is consumer welfare. Consumers should not be harmed in any way. Choices should not be, there should not be deprivation of choices. So what they do, they try to keep the consumer always happy. And in keeping the consumer happy, they create this ecosystem with the help of very, very strong algorithms. And these algorithms, they judge the mood of the buyer, and they create a structure which is just unbeatable. It itself makes a barrier to entry to a new player. So it's easier said than done that there is a dynamic competition. Dynamic competition is there. But who will beat Google? As of now, who will beat Amazon? You have to have a better system than them. Unless you have a much smarter and better system, you just cannot beat them. So what happens is, the moment you are a startup, they acquire you. So they do not let the competition actually emerge. When they see potential in a player, they acquire. I'll give you an example. So Facebook acquired WhatsApp in 2003 when it for $19 billion. When at that time its worth was hardly $1 billion. Why? 19 times they paid to WhatsApp to acquire, because they saw the potential in WhatsApp. So today, Facebook and WhatsApp are one. So imagine the kind of power they acquire. So as I said, they create a private competition within their own ecosystem. And that's why no wonder that they are described as centers of large empires. You know, there's one Miss Vestager in the European Union. She's a famous European commissioner of competition law. Miss Margaret Vestager, she says, the centers of large empires. Due to their strong market powers, these e-platforms can use and do use all sorts of vertical restraints to soften their inter-brand competition. They frequently use advanced analytics, as I said, and they also indulge in certain prohibited vertical restraints such as resale price maintenance, exclusive arrangements, preferred sellers, etc., etc. But do we understand the problem? The big problem is faced by antitrust authorities is this: how to define the relevant market in case of online sales, to determine whether the e-platform has acquired significant market power or has acquired a dominant position in the relevant market. Whereas an over-intervention can kill a dynamic market, no doubt, and under-intervention can damage fair competition. So they are in a dilemma. Antitrust authorities all over the globe, including the Competition Commission of India, is always in a dilemma whether, when, how much to intervene. So let us proceed with some of the major issues. Exclusivity clauses, as I said. Exclusivity clauses by dominant platforms is one of the major concerns. So role of algorithms, single, by the use of algorithm, they create what is called as a loyalty, single homing. And I give you an example of cat and dog war in China by Alibaba. It's a famous case. And then the business interest takes in some preferred sellers or related entities or subsidiaries selling goods or services to indulge in self-favoritism by searching their rankings on the platform and also by giving deep discounts. So these are the cases which are highlighted in red ink. Google search, Amazon, Apple investigation in India, even Amazon and Flipkart is going on. I can take you the questions on that, but I would avoid going into the matter is sub judice. And then platform governance system itself, or ecosystem, a dominant platform, raising rivals cost or exclude a participant on the site that competes with the platform's own service. Imagine the case of Apple and Spotify. So on the Apple store, you see, you got Spotify also, you can download that. But Spotify has already filed a case against Apple in the US. There are so-called music wars are going on. So in this context, if you can see, the Competition Commission of India conducted a market study. And the study was released on 8th of January 2020. And it was an extensive, I was also part of the study. After an extensive 8-month study, survey of all these categories, of the e-commerce, see, these are the key findings. So please have a look at them. Platform neutrality was found to be violated. So the departmental, the shopping mall no longer remained a shopping mall, it became a departmental store, so to say. Then platform to business contract terms were found to be one-sided, unilateral, because as I said, they were opaque. The third was the platform price parity clauses. So you see, this is very interesting, and you must understand this. So suppose if you book a ticket or a hotel or a holiday on Make My Trip or Clear Trip. So what happens is these platforms, they've got a what is called as a white parity clause. They've got a contract with the seller, with the hotelier or with the airline providing tickets, etc., that they will not, provide a better deal to their customers on any other platform. So all platforms are excluded. This is called white parity, and this is prohibited now in Europe. In India, we have yet to, this case is still going on to Make My Trip. Let's see how CCI decides it. There's another one which is known as this narrow parity. What does narrow parity mean? that the contract terms prohibit the seller from giving better terms to its customer as it will give it on its own website. So that is narrow parity. Narrow parity is still acceptable. Then there are exclusivity agreements. Agreement where a certain product is launched exclusively on single online platform, as well as agreement where a platform lists only one brand, etc. And then the deep discount. The deep discount is something very unique to developing countries, in India particularly, because they've got deep pocket, they just fund money and they burn cash. There's a research. In fact, I spoke on a webinar during the lockdown, and I explained how billions of dollars these Uber have plunged into the Indian market. It was a study conducted, and how Amazon has, to enter, although they say we are entering a new market, it's called introductory pricing, but actually it is in a way predatory price, because the price at which they afford to sell, nobody can match. And I give you examples. You must have seen those on Diwali and other festivals. You see the big billion days like used to be there. Similarly, you must be familiar with full size ads on the front pages of all the newspapers, the particular days, and you will see the price of mobiles are so less, 70%, 60%. No online vendor can afford to match that. And I have been contacted by people from all sides of these mobile markets, and we are helping them that how to find this. That's why the case is going on. So the All India Online Vendor Association case is on. The case filed by AIMRA, the All India Mobile Retailer Association, is on against Amazon in CCI. Even the CAT has come into the picture, the Confederation of Indian Traders, they also filed a case. So these are the issues which the CCI actually notified. Let me explain you a bit of them, little more. So search ranking. Search ranking parameters are to be set out in the user terms and conditions in intelligible and ambiguous terms. But possibility of a search parameters being influenced by any direct or indirect remuneration paid by users. So platforms to set out a detailed. So these are the self-regulatory mechanisms which the CCI actually indicated after the study. So you must see this. These were the conditions the CCI, when it came out with the study, suggested. Because CCI wanted to go, as I said, it was in a dilemma. It wanted to give what is called a soft glove treatment to e-commerce, because e-commerce ultimately was benefiting the consumers. So being consumer friendly, CCI also had to be very careful. So these are the self-regulatory mechanisms which CCI indicated to the platforms. First was search and ranking should be very fair. Any such disclosure should not enable the manipulation of search results. Collection, use, and data, sharing of data. So they were expected to formulate a transparency policy with respect to collection and usage of data, and also include a potential and actual sharing of such data with third parties or related entities. Then user review, maintain transparency in publishing and sharing. This was particularly for the OTAs, sharing user review and ratings with business users. Rating and reviews are supposed to be authentic. Mechanism supposed to be devised in place to prevent fraudulent reviews and ratings. When the revision in contract terms are also suggested, the prior notice be given to users in case of any proposed changes. Proposed changes to be implemented only after expiry, blah, blah. And the notice period should be reasonable and proportionate to the nature. So, and discount policy, of course. So on each aspect of their findings, you see, the discount policy was supposed to be clear and transparent, and the platforms are expected to specify the basis of the discount rates funded by the platform different, and implication of business user participation, non-participation in the discount scheme. Well, let's see some recent developments. I hope till now I just tried to give a bird's eye view over the issues. So let me just take you through some of the cases which are now going on. The first case was the investigation ordered by CCI against Amazon and Flipkart. As you say, as I told you, the study came out in January 2020 beginning, and on 30 January, after immediately a week of thereafter, the CCI directed investigation against Amazon for the alleged deep discounts to preferential sellers, preferential listing of sellers, and exclusive tie-ups and exclusive launch of products. Mind you, before I proceed, none of these platforms were held to be dominant. They could not be, because there was competition. So Amazon, if Amazon is there, there is Flipkart. So none of them would attract Section 4 of the Competition Act. So the CCI did try to move them under Section 3, subsection 4, that is the vertical anti-competitive agreement. And these were the three areas which they found were and they found some evidence of these areas also. Since the matter is still on, the inquiry is on, so I will avoid going into details of this. But deep discounts were found, provisional listing of sellers was found, there were exclusive agreements found, there were emails actually called out by the CCI during the preliminary inquiry itself. But what happened? You are all aware the Amazon and Flipkart went to High Court. Karnataka High Court stayed the order and investigation. And what was the observation of the Karnataka High Court? That investigation into the provision of FEM Act was still in progress. CCI in order recorded that there appears to be exclusive partnership between brands should have formed a privacy opinion and possible collusion. But this is as I said, I could not update my slide. This is an old slide. After that, what happened was the Karnataka High Court ultimately dismissed their case and said that yes, the case of FEBA is different, which can go on under Section 62. But Competition Act can also, Competition Law Commission can also investigate. Against that, they went to Supreme Court, and Supreme Court has also dismissed their SFP, and the matter is in the CCI now. So they've exhausted all channels possible in India of stalling the investigation, the antitrust investigation, but they have not been successful. Now, All India Online Vendor Association case was the second case. The NCLT recently quashed. As I said, it's an old slide, please pardon me. So the order of 6/11/2018 exonerating the Flipkart and direct. In fact, what happened, this is a very interesting case. So in this first case of 6/11/2018 order, till 6/11/2018, CCI never thought or never considered the e-commerce to be a separate market, to be a separate relevant market. It said it's a part of the overall retail market, of which its share, as I said in the beginning, is very less. If the online share, if the share of the online business of the total market is just 6 to 7%, CCI said how they can be dominant. So CCI actually closed that case against Flipkart, which was filed by All India Online Vendor Association. The issues were the same: deep discount, provisional listing, etc. But CCI said till we find them to be dominant, we cannot take. And even at that time, the evolution had not become so much in the competition jurisprudence. The CCI did not want to attract Section 3 subsection 4. Right? So since they were not found to be dominant, the CCI closed that case. And against that case, the appeal was filed by All India Under Association, and the NCLT then quashed that order of CCI. That's what the bullet says. And they say, and very interestingly, I must tell you a little more about it. In this case, what happened was the NCLT found that the Flipkart had actually, before the income tax authorities, while booking losses for their in their books of account, had actually admitted that these losses were deliberately caused to enter the market by doing predatory pricing. So they say we wanted to beat the competition, so that's why we incurred losses. So that piece of evidence was considered by the NCLT as an evidence sufficient enough to show that there is a predatory pricing. Now, against that also, you see the Flipkart went to the Supreme Court. And Supreme Court also picked up the same portion of the evidence of the NCLT order and dismissed their case. That's why this case is also going on. So that is the stage. Now the next case was, as I say, was investigation to Make My Trip, Go Ibigo, and also this also an old slide. So CCI on 2019 and 21-20 directed investigation against Make My Trip, Oyo, and possible contravention of course, in this case, the CCI held that Make My Trip is dominant, and they found the agreement between Make My Trip and Oyo in the nature of vertical agreement, which were restricting the market. The issues were these three, as I said: parity restriction, wide parity, exclusivity conditions and agreements, and a certain agreement with the MMT and Oyo. So this is, of course, the presentation. I'm done with the presentation. We can take questions if you have, but otherwise, if you want, I can take you through more recent developments.
Now the floor is open for the questions.
If you want questions, otherwise I can update you on more recent development. In fact, if you, I'll just share you the screen. Give me a minute. Kindly hold on. Because if you are interested, if you guys are interested, just because I keep on updating myself on my blog itself. So my blog is my. So this is the latest thing now is the dead Amazon jump gun in India. You must have heard of newspaper that CCI has suspended the clearance given to Amazon future deal and imposed 200 crore penalty.
Yes, sir.
So this is the blog on that gun jumping. I've described gun jumping. You can read. Then if you go back, if I take you to the next blog, will India follow Australia in forcing Google to pay? This is another recent thing which has happened. So Google, the investigation have been ordered against Google by CCI on the complaint filed by Digital Newspaper Association. See, they say that like Australia has directed Google to pay fairly to the content which they derive from the media. That should happen in India also. That's why my blog says, will India follow Australia, forcing Google to pay fairly for news content? CCI ordered investigation against Google for fairly and for unfair and arbitrary terms of news content. So in Australia, for information, the Digital Platform Inquiry report actually led the Australian government to impose a mandatory code for the Google and Facebook to pay for the news content. That code is still to be operationalized, but that is a big debate there. But in India, we are starting from the scratch. So this order of 7/1/2020, very recent order of CCI. You can open this on the website of CCI if you want. Please go through this order, you'll see. This case was filed by Digital News Publishers Association, India Today Group, against Alphabet and Google. It's Google's parent company, right?
Yes, sir.
So this way, and if you just give me 2 minutes more, I'll just take you through some more recent developments. So Amazon, Google, and then Apple. Yeah, this is another interesting case. So even Apple is facing antitrust investigation again in India for its alleged abuse of dominance. And abuse of dominance for what? Of course, I wrote a blog earlier with this still to come, Apple app tracking policy, but let me tell you this. Market for non-licensable Apple Smart Mobile Operating System. Market for App Store for Apple Smart Mobile Operating System. Market for apps facilitating through UPIs. So like the Google case, if you are familiar, investigations are going on against Google. There are 3 investigations going on against Google. I can tell you that also. Just a second. No, this blog itself I said about Google, I think. Yeah, in this blog itself I mentioned the 4th investigation. Yeah, this would be the 4th investigation ordered against Google. The previous 3 being this. The first order was against for use of its Android operating system on smartphone manufacturers in India. So they used to have MADA called agreement with the smartphone maker. This inquiry is still on. They used to have very highly one-sided terms. And then another inquiry was against abuse of dominance by Google Pay in the market for online app-based system. So if you purchase through Google Android, Google's App Store, Google Play Store, the one of the conditions which they impose on the app developers is that you must direct the payment through the Google's own interface, Google ePay. And then 3rd investigation was for smart TVs, Google for operating OEMs for smart TVs. And now this is the 4th investigation which I just said about the news content thing. So Google, like Google, you got Google, you got Apple, you got Amazon. So all the big GAFA, as you call, most of them are facing antitrust investigation in India. So you can imagine the e-trust, the e-commerce or the electronic digital media is facing, the brunt of the heat. And these are the recent, I mean, you can just go through in fact, this one I just try to argue whether Amazon can be tamed in India. Antitrust probe, because it's the first probe to change its modus operandi. I mean, if you are interested, please go through these blogs. We'll give a lot of readings, particularly for the students and even the teachers who are interested in teaching competition law, getting an insight into the real issues, because as practitioners, we represent either of these parties sometime, but when I'm not representing any of them, then I give my independent view as well, and I'm quoted in the newspapers also for this. I think with this I should stop. If there are questions, I'm there.
Sir, can I ask a question here, sir? This is
Please.
here. Sir,
I'll stop sharing now.
Yes.
Yes, sir.
Yeah.
Sir, first of all, I must say that it is a very insightful session that we are having, sir, today, and really enlightened by way how you actually presented the different facets of in an e-commerce environment, how these things are working. But having said that, I want to also understand from the perspective of sir, when we talk about information sharing per se, does the information sharing, suppose in the instant, suppose a case is being hypothetically, if I'm drawing up a case, for example, if the competing companies are sharing customer retention strategy or pricing strategy, which is a very much part of the today's business, as I could understand from your slides, is that certain kind of business of modus operandi or the general business model in a B2B model or B2C model also, there are certain kind of MFN status which could be given by the which are basically feature oriented. For example, if I'm sharing a customer retention strategy, it could be for rationalization and efficiency in the market. For example, a director, I mean, do you construe that if an independent director is in the board of a company which is having, say, 7 members, and eventually that independent director has 14% say in the control and having less than 10% shares in another company, competing company I'm talking about, through horizontal.
You're talking about cross ownership. Cross
ownership, cross holding for that matter, sir. This kind of thing, for example, sharing of customer retention strategy or pricing strategy, do you construe them as actually the components of actually starting or triggering that kind of anti-competitiveness in the market, or which has a potential to become AAEC in the long run, sir?
A very good question.
Yes, sir.
I understand. I'll give you my thoughts on this.
Thank you.
Information sharing is, there are guidelines. You must be aware in the European Union of horizontal guidelines are there. And in that, information exchange is one of the key components. So there are clear-cut, safe harbors given. There are clear-cut, guidelines given. So in India, we unfortunately don't have guidelines. We have a law only. We have only Section 3 of the Competition Act. Guidelines have yet to evolve because we are new jurisprudence as far as antitrust is concerned. So what happens is information exchange to the extent. Now you have to see the context in which you're talking. If you're talking in the context of merger control, the analysis will be different. But if you're talking in the context of antitrust per se, that is, suppose you're examining a case of an allegation of 2 competitors. Suppose Hyundai and Honda, right, were to share their, what we call their sensitive information, right, to create a situation where they try to capture the market. Certainly, and then it will depend on the market share they have. It will depend on the, you see, ultimately antitrust is what? Antitrust, the basis of antitrust is to stop exercise of market power, whether it is singly by a single firm dominance or it's collectively. So when you join, you kind of coordinate with each other. It's called cartel, loosely. It may not be actually a cartel. But even if a coordination is there, if it leads to reducing the uncertainties in the market, I have written extensively on this issue. So anything which reduces the uncertainties in the market, which would otherwise prevail, but for that sharing. You see, in a competition, you're supposed to be always guessing what your competitor is doing. But if you start coordinating with each other and you're reducing that uncertainty, right? So that is wrong. You may be right practically that how it will depend, sir. It will have to be investigated. So there can't be a straight jacket answer to it whether it is right or wrong. But certainly it will have concern. My very careful worded answer would be it will have concern. If you have direct competitors, if you're sharing information, and if you hold substantial market share in the market. If you're a newcomer, yes. A new platform, yes. Doesn't matter. But if you are an established player already, right, then certainly it will have affect the market.
So this is subject to investigation by the CCI.
Yes, it can be
via the DG's investigation mechanism.
Correct. It will lead to that. If it will, you see, there are these examples are already on in these. I don't have time to take into the cases. There are cases going on. Information is asymmetry. Very much information exchange is a very much serious, even in the merger control. You see, they try to see that this is done away with. Why they want the competitor to diversify is this reason, because they should not. You see, I'll take you a case of a joint venture. You make a joint venture. So when you make a joint venture, your competitors. So joint venture is supposed to be exempted from Section 3.3. There is a proviso given that if it is a joint venture between competitors, which leads to efficiency generation, then it is not presumed to have what is called as AAEC, appreciable adverse effect. Correct? So that being the case, even the joint ventures participants have to have what is called as a clean team. Till they actually merge, till they actually create the joint venture, they're not supposed to be knowing. They're not supposed to be doing information exchange, because that can also lead to, we keep on getting opinions, questions from all over the globe of these things, because this is normally the clean teams are made until the joint venture actually comes into play, and that is approved by the Competition Commission of India. Even joint venture is supposed to be filed. So the commission will see, because before you actually create a third party, a third platform, which will purely do business on independent business. It will be an independent, joint venture, full function. It should be full function joint venture. It should have an independence as far as marketing is concerned. So parents should only help it. The parents should, under the guise of joint venture, they should not compete. They should not coordinate their strategies. You understand? Efficiency generation is granted, but to an extent, it cannot be an alibi for coordinating between companies. That's my answer.
Yes, sir.
Thank you very much, sir.
Yes.
I mean, I can't give you more than this, because this is again a gray area. I appreciate your question, but it's actually
I
a
think,
gray
sir,
area.
you substantially answered the question.
I try to. I just try to.
Fantastic.
Yes.
Thank you, sir.
Yes. So now we have come to the end of the session. On behalf of Marathwada Mitra Mandal Shankarrao Chavan Law College and University of Italy, I, Assistant Professor Mayura Sabne, Program Officer of this international conference, would like to propose my vote of thanks to Advocate M.M. Sharma, sir. Thank you, sir, for taking out time from your very busy schedule and enlightening our audience about the niceties of the e-commerce and the competition law. We were unaware about all these practical aspects, how that e-commerce is actually correlated and having an interdisciplinary approach with the competition law. So thank you once again, sir. And we extend our invite to be physically associated with our college in the near future. Thank you once again.
In fact, if you allowed me to say, I would request all the participants to just join my blog.
Yes, sir, surely.
I mean, just subscribe to the blog if you, I'm sure you're going to, because it's all.
Participants, there is an announcement that the link for the feedback form of this session has been shared into the chat box. Please fill the feedback form in order to get the certification. And today we have concluded day 1 of the international conference. Tomorrow morning, we will be starting sharp at 9 a.m. with the second day and with the next session of the conference. Thank you for attending the same. Thank you, sir, once again.
Thank you, ma'am. Thank you.